Welcome to the Johns Hopkins Bloomberg School of Public Health for this meeting on hepatitis C and Section 1498. We're going to start with a video message from the Louisiana Health Secretary, Dr. Rebekah Gee.
Good afternoon. My name is Dr. Rebekah Gee, and I'm Secretary of Health for the State of Louisiana. In our population, over 73,000 people have the condition hepatitis C. This condition is a debilitating illness that can lead to severe disability or even death. The great news is that hepatitis C can be eliminated with drugs that are over 99% effective. The bad news is that I come from a poor state, and in my state, the affordability of these drugs from a population level is just not there. Recently, Sloan Kettering and Dr. Peter Bach worked with my team to help create an abacus that shows the trade-offs that would have to be made to eliminate Hep C in my state. To do this would cost almost $800 million and would require major cuts to higher education, K through 12, roads, and other important public services. Given that this demonstrates what we already know when we budget every year for the Medicaid program, I'm looking for creative solutions to this problem. I recently read the report of the National Academies of Medicine that talked about the possibilities of a company licensing the drug to the U.S. government for the purposes of providing hepatitis C treatment to vulnerable and low-income populations. I'm also interested in the use of 1498 authority to help provide drug to neglected populations in a condition of a public health crisis, which is where I think hepatitis C is now in our state and in our nation. I'm asking you today to look at these two options and to recommend to me whether I should contact the Secretary of HHS to see if either or both of these options should be employed to alleviate the public health crisis of hepatitis C in our state. I hope today's proceedings are interesting and come with some great recommendations that can help us improve population health in Louisiana, a state that has consistently been one of the poorest in the nation and has rankings on United Health rankings of 49th or 50th in terms of chronic disease and morbidity. Look forward to hearing from you, and I hope you have a great day.
Great, thank you, Dr. Gee. So thanks to all of you here who have come from different places or are dialing in from different places to help us address the questions that Dr. Gee asked. She has written a letter setting out the public health challenge of hepatitis C in Louisiana and asking us to explore the recommendations of the National Academy of Medicine and the potential utility of 1498 for addressing the public health crisis of hepatitis C, and that's what we're going to do over the next few hours today. We've got some great people here who will introduce themselves as they're talking. But why don't we maybe start with a quick introduction of just so people know who's around the table, and then we'll jump into the program. So I'm Josh Sharpstein. I'm Associate Dean for Public Health Practice and Training here at the Johns Hopkins Bloomberg School of Public Health. Let me go this way.
I'm Jerry Anderson, and I'm a professor in the School of Public Health.
Rachel Sachs, a law professor at WashU in St. Louis.
Associate Professor.
Peter Bach, I'm a physician at Memorial Sloan Kettering Cancer Center.
Jeremy Borick, a soon-to-be assistant scientist here at Johns Hopkins.
DT Sen, assistant professor here at the School of Public Health at Hopkins.
Jeremy Green, I'm a professor of medicine and the history of medicine here at Johns Hopkins.
Anna Brennan, I'm an associate at Hagens, Berman, Sobel, and Shapiro.
Great, and Amy, do you want to introduce yourself?
Yes, I'm Amy Kipchinsky. Can you all hear me okay now?
Yes.
Great. So I'm a professor of law at Yale Law School.
Fantastic. We may have a couple other people joining. We'll introduce them as we go. So before we go further into exploring these questions, we are delighted that Dr. Bach could make it here, and he is going to just do a quick demo of the tool that Dr. Gee referred to that addresses the cost of hepatitis C treatments for the state of Louisiana.
Great, thanks. And So hopefully this technological portion will work a little bit better than the last one. As Dr. Gee mentioned, my group at Sloan Kettering took it upon ourselves in working with the state to try and address sort of the budgetary constraints the state had and try to essentially find the money to pay for Hep C treatment. As Dr. Gee mentioned, the state's heavily constrained from a budgetary perspective. Of any particular annual budget they have, little is actually in discretionary silos that they could reallocate, and they have a large Hep C burden. They also actually have a current deficit, so we're really starting at zero. But we did sort of construct something, an approach, so we could see sort of where else they're spending their money, and if they moved it around to pay for Hep C, where they could find it. So our estimates, triangulating from actually a number of sources, they have about 20,000 people in either singly eligible Medicaid or dually eligible Medicaid, Medicare, people with hepatitis C in the state as well, and then 15,000 people who lack insurance with hepatitis C. Based on the available prices for treatments with Harvoni and a blend of the different durations of that therapy that we get from Gilead, we then figured out how much they could cut their budget and whom they could treat with that money. Included in here is an assumption that they would open up access in the state, which gives them Gilead's lowest price that they announced at the end of 2016. Also assumed here is the FMAP, or the federal matching percentage for Medicaid, both within the standard Medicaid program and within their expansion population. So sort of getting as far as we can with each dollar. But this allocator, which we're going to put up later, probably in a few days, allows users to actually go through and address these basic questions of where you could get money. So as you can see here, we displayed for the state the number of people in the current budget who are receiving Hep C, and then how many recipients would be affected in Medicaid as well as students. There's actually 5 buckets of funding. These could be monetized easily at a per head basis. These fixed cost sort of things, state administration, social services, and infrastructure, we couldn't. But what the tool allows individuals to do is actually go through and reallocate things like, it turns out reducing Medicaid for the disabled and visually impaired, which is a selective budgetary expansion category, is actually quite efficient, for example, in terms of creating money for hepatitis C treatment. So you could, for example, generate, this much money, about $0.12 billion by taking people out of this program. Taking 4,700 people out of this program would generate enough money to treat 14,000 people with hepatitis C. And you can go on and experiment with reducing benefits in other places as well. Medicaid for low-income children, for example. Public education, you can defund things like higher education support. You can see we're still not there, and you can reduce the number of people getting K-12 education as well. And you can see the terrible challenge that the state faces. They're barely halfway towards the budget of having to treat Hep C. There's a minor cost offset. Everyone talks about Hep C treatment saving money. That's in there. Those are the best estimates of those savings. And this is the number of people who would be affected. 31,000 people losing Medicaid eligibility, about 22,000 students losing support for their education. And that doesn't get you where you need to be in terms of treating Hep C in the state. All of this is annualized, so all of it is, if you will, the thought experiment of do this all in 2017, which means the loss for the Medicaid recipients is for 1 year of benefits, the same for the kids. They only lose 1 year of education, and the way education works, maybe they'll be better off with that. But that's the idea, and then it's a reallocation for the treatment also in the same year. You could argue you can stretch this out, but these are essentially person years of services being removed. So if you treated people for 5 years for Hep C rather than just 1 year, you would affect the same number of individuals for the same number of years. We did sort of imagine other scenarios. There's some reasons why actually delaying treatment is net negative. So stretching it out obviously increases to a modest extent the number of new infections that would occur because you're not reducing prevalence as fast as you can. But it's also the case that the costs that patients incur as their disease progress also rise. So the cost to the state, it's not free, if you will, to delay treatment. Although, again, those are pretty much smaller scale effects than these major ones. So I'm happy to take a few questions or any questions on this. But this is essentially this is what Dr. Gee was talking about.
So I'll ask you one question, Peter. Why did you do this, and related, what do you think it shows?
Yeah, I actually think, these are very big numbers, the number of people with the condition, the amount of money the states spend, these various buckets of services, how much a treatment costs. And I have found it useful to reconcile all of these numbers in a single place so you could sort of gauge the scope of things. Because it's very easy to say offhand, well, yeah, you'd have to fire a few nurses to pay Hep C, but I actually think it helps to get a sense of the scale. So the huge numbers on Hep C, the huge numbers of people you'd have to throw out of Medicaid programs, if you will, reduce, the other ways you could reduce benefits across the board, which is harder to display in the same way, but has the same actuarial consequence. So I think it's actually useful to, because at least I think for most policy, it's difficult to think once you're over about $10, $100 million, $100 million, $1 billion, they both just sound like very large numbers. But they're obviously quite different when you start counting up the people that they can help.
Great. Any other questions for Dr. Bach?
Peter, does it include the prisons?
No, prisons are not in here. Most people in prisons in Louisiana would be Medicaid eligible outside the prisons, but they are not once they go in. They're part of the prison healthcare system.
Wouldn't that add to your cost?
Yeah, this ignores the prisoners. There's tens of thousands of prisoners in Louisiana. The prevalence is probably about 33% in the prisons. Tens of thousands of people who have had Hep C, and it's probably the greatest zone of transmission. We only focused on single and dually eligible Medicaid and uninsured. There's also the veterans system. There's people in traditional Medicare alone. There's people with commercial insurance. Those add up. Dr. Gee mentioned 73,000 in the state. This focuses on 35,000 of them for whom the state could have a direct role.
Right, but in the prisons, aren't they the state prisoners?
They are, but it's not budgeted that way.
So this is an underestimate.
Way underestimate.
Well, no, the exercise was not intended to eliminate Hep C in Louisiana. This was a narrow focus of what the state could target within its current kind of budgetary construct.
But the story is much worse if you include the prisons. I mean, they
Yes, absolutely. I think a harder question is what even this mechanism of the state would be to pay for treatment within the prison. So this is a practical exercise of what the state could do when they reallocated their budget.
Right.
Not sort of how big is the problem in Louisiana in general, which is much bigger. Commercial costs are also higher than they are in Medicaid, and there's a big chunk of patients in there too.
Great. Thank you very much, Peter.
Thank you.
So we're going to switch back to our previous view, I think. Great. So we so far have tried to set the table for our discussion. So that was terrific. We had a great message from Dr. Gee. We have a major public health challenge in Louisiana. And what I take from that presentation is that it's not solvable by conventional means. There is not money in the budget that can be easily reallocated, even to solve a portion of the problem that fits under current budgeting. So that is why Dr. Gee asked us to consider some extraordinary options. One option was just set out by the National Academy of Medicine panel that was convened on the elimination of hepatitis. And it talked about having a competition for companies to sell their license to the federal government. So that was one option. Another option that she asked about was Section 1498. And this is a very interesting section of the law. We have a couple of the world experts on it here with us today. So we're going to turn to Hannah Brennan, who with Amy Kapczynski wrote a great paper on this, to give a broad overview to kind of set the terms of discussion around 1498. Thank you very much for coming.
Thank you for having me.
So yeah, as Dr. Sharfstein mentioned, I'm Hannah Brennan, and I'm just going to give a little bit of a history of Section 1498, how it was drafted, why it was drafted that way, and the content of this paper, as Dr. Sharfstein mentioned, is based on a paper I wrote with 3 other co-authors, Amy Kapuscinski, Christine Moynihan, and Zane Risby, and I just want to credit them with a lot of the research that you're going to see in today's presentation. So, well, I have the slide changer. So I just want to start with the text of Section 1498 before I delve into its history. As laws go, this is a pretty short one, which really means that we have to rely on the drafting history as well as the case law to interpret it. But right now I just want to highlight a few key parts of it. So first, the law mentions inventions. It doesn't mention patents. And that's because the intent of 1498 is to really allow the government to use whole technologies, whether they be drugs or weapons or software. The law really envisions the government being able to use important technologies. Next, the law does not require the government to negotiate a license with the patent holder, speak to them, have any conversation with them. The government can just take a license to their technology without asking them first. And if the patent holder wants recovery, they have to come meet the government where it sits in Washington. You have to file a claim at the Court of Federal Claims, which is in a building right next to the White House. And then when you appeal your trial decision, you appeal to the Federal Circuit, which is in the same building. So you really have to come to the government and ask them to compensate you for using your patent. And the only compensation you can get is reasonable and entire compensation. And I'm going to talk later on about what that means and how that's been interpreted in the past. The last section I have highlighted here, I'm not really going to talk about. I think other speakers today are going to touch on this. So to start, for a long time, if the government used your patent and manufactured the technology that your patent was on, you really had no recourse. And that's because the federal government is immune to suit. You can't sue the federal government unless it's consented to be sued by you. And up until 1910, the government just did not consent to be sued by patent holders. And so the only way that patent holders could really try to get compensation for the government's use of their patents was to go to the Committee on Claims in Congress and basically ask the Committee on Claims to give them some compensation. But as this quotation up here recognizes, they basically had tons of petitions sitting in front of them, and they weren't able to pass on each one. It was a really inefficient way for patent holders to try to get compensation for their patents. So Congress decided to do something about this in 1910 and basically passed the precursor to Section 1498. And this law basically said, we're going to give reasonable compensation to patent holders, but they cannot get an injunction, and the government should still be able to, just as it has in the past, continue to use patents when it needs to. And this quotation up here really just shows that the government didn't think, they really saw themselves as having a right to use the patents that they had granted themselves to patent holders. And that, the compensation was just sort of in fairness and injustice to these patent holders, they'll give them some compensation. So the natural question that came out of the passage of the precursor to 1498 was basically, how far does this waiver of federal sovereign immunity extend? Who is protected within its umbrella? And the picture up there is of a Philly shipyard of this ship manufacturer. Basically, at the dawn of World War I, there was a bunch of ship manufacturers, and in particular this one, William Cramp, that were manufacturing ships for the U.S. government. And this ship manufacturer infringed Curtiss Marine Turbine's patent on some turbines that it was using to manufacture its ship. And Curtiss sued William Cramp and basically said, you're on the hook for your patent infringement. And William Cramp said, no, we're not. The federal government asked us to make these ships, therefore the federal government should be on the hook under this new law that has been passed. The federal government said, no, we don't think we are. Reached the Supreme Court, and the Supreme Court basically said, no, I'm sorry, this contractor is on the hook for the infringement, they're going to have to pay the damages. Which of course, we can't see that, I had pictures behind this, but basically this created a lot of upset because the government is, at war. They need cheap weapons to be manufactured. They don't want to be price gouged by the defense manufacturers. And so the then acting Secretary of State, who was FDR at the time, went to Congress and said, please amend the law so that it's clear that our contractors can actually use the precursor to 1498 to make inventions on our behalf, and so that they'll be covered by our umbrella, and that the suit will come against us and not our contractors. And Congress responded, amending the law in 1918, and basically it made it very clear that the government was liable for the infringement of their contractors. And that's this is a Supreme Court case that basically interpreted the law as it was supposed to be interpreted and said the purpose and the intent of Congress in the 1918 Act was to stimulate contractors to furnish what was needed for war. After those amendments in 1918, there was basically 2 more amendments in 1942, which brought us to what the current version of 1498 looks like. They basically expanded the protection for contractors to include subcontractors. So it just sort of broadened the scope, actually, of 1498. Now I just want to talk a little bit about the early uses of 1498 to procure medications. So as I said, this presentation is based on a paper I wrote with other co-authors, and I would say for the first 6 months we were researching the paper, we had no idea that this section had ever been used to procure medications. In fact, we found quotations that said it's never been used before to procure medications. So eventually when we realized that it had, we were quite interested in the uses. Basically, in the late 1950s, the Comptroller General of the United States issued an opinion that said whether or not a contractor's product would infringe a patent shouldn't be considered when deciding whether or not to grant that contractor the contract. So that basically opened up government suppliers to patent infringe. And they could do so under 1498. So the first big example is tetracycline hydrochloride. Pfizer was the patent holder on this antibiotic, and the government wanted, the Department of Defense wanted to procure this drug. And so an Italian manufacturer at the time, Italy didn't have any patent protection, offered to produce this medication for 72% cheaper than Pfizer was going to produce it. When Pfizer found out, they actually offered to drop their price from below what they were offering the drug on the US market, but the federal government basically said, too bad, the Italian manufacturer is going to give it to us for much cheaper and we're going to go with them. So as you can imagine, in the wake of this decision, Pfizer lobbied pretty hard to amend 1498 and get rid of it. And the government held strong, and the comptroller pointed out that it was a really important provision in order for the government to get medications that it needed. After this decision, this 1498 became routinely used throughout the 1960s. Indeed, the Department of Veterans Affairs used it a ton, and we found that according to one source, the Department of Defense relied on Section 1498 to procure 50 drugs in a 3-year period for a total savings of $21 million, which was a lot at the time. And so this was sort of a really important and routine use that the federal government engaged in. Unfortunately, there's not much case law about how royalties were set in this period because the conflicts over government taking of government use of patents on drugs were settled out of court because presumably the patent holders didn't want to set bad precedent on what royalties should be. One of the few examples of royalties we have is the government used, I think it was the Department of Defense, used the patents on diazepam, and it was a 2% royalty that came through in government hearings, so a very low royalty rate for government use. But in the early 1970s, late 1960s, the use of 1498 to procure patents really petered off. And basically, there was a hearing in 1971, and the Comptroller General was asked, why are you not continuing to use Section 1498 to procure drugs more cheaply? And the answer was basically, we're worried about liability. there's a great uncertainty of suit. You know, we don't want to expose ourselves to risk of lawsuit. But that explanation really doesn't make much sense given that they had been using 1498 pretty successfully throughout the entire 1960s to procure drugs. So some of the other possible explanations are lobbying from the pharmaceutical industry just caught up with the government. The lobby became bigger and stronger, and that worked out. That's a possible explanation. Another possible explanation is that there were some changes in the drug regulatory law in the mid-1960s and then in the 1980s. And it could have been that the federal government was worried about the quality of foreign drugs. Generally, the generic suppliers were foreign suppliers. And there's a site from the VA that basically states that they were worried about quality of foreign drugs. Other possible explanations were the change in administration from Johnson to Nixon, and basically a rise in proprietarian thinking about intellectual property, basically seeing intellectual property rights as akin to land rights and sort of believing that they were stronger than had previously been thought. In terms of recent uses of 1498 for medications, there's only one real case, and it's not even a technical use of 1498. After September 11th, when there was the anthrax scare, the then Secretary of Health and Human Services, Tommy Thompson, basically said, we may use 1498 to procure Cipro, and as soon as he said that, Bayer lowered their prices. So that they never actually needed to use 1498, but this sort of example shows just how powerful even seriously invoking 1498 can be in terms of a lever of reducing drug prices. Since that example, the Cipro example, to my knowledge, 1498 hasn't really been talked about to get medications, but it's routinely used by the government in other areas. So this is a table that I grabbed off of the government's judgment fund, and it just shows all the different departments of the government that have been using 1498 in the past couple of years, and it shows the amount that they've paid as reasonable royalty. And you can see a broad range of government agencies, from the National Park Service to the National Gallery of Art to the Department of Army, use it. And we've seen case law where it's been used for night vision goggles to waste removal software, waste removal technology to bank fraud detection software. So really a broad range of agencies avail themselves of 1498 without issue. So there are basically two interpretive questions when it comes to use of 1498. I'm not going to go into the first one because I think it's going to be discussed later on, but I'm going to talk now a little bit about what reasonable and entire compensation means. This is sort of a key provision of the text. You have to give reasonable and entire compensation. What does that mean? So the Federal Circuit, which is the appellate circuit that oversees this case law, has basically said there are three ways to calculate reasonable and entire compensation. You can do a reasonable royalty, you can do cost savings, government cost savings, or you can do lost profits. And I'm going to start with the third one first. So lost profits is exactly what it sounds like. It's how much has the patent holder lost in profits because the government used its patent. And this is strongly disfavored, largely because it's extremely speculative. It's very hard to prove what your actual lost profits would be, and it's so hard to prove in part because the Federal Circuit has required a clear and convincing evidentiary standard, which basically just means you have to show, but for the government's use of my patent, I would have had X amount of profits. This method of determining reasonable compensation is also disfavored because it doesn't quite comport with the goal of 1498. It's lost profits is seen as almost as leaning towards excessive, as overcompensating the patent holder. And the whole point of 1498 is to avoid excessive compensation. 1498 was, the governments use patents because they can't purchase them at a reasonable price from the patent holder. And 1498 recognizes that that's an issue and wants to make sure that the government doesn't have to overpay for patented technology. And those are two quotes from the Federal Circuit that just sort of capture that concern about what reasonable compensation is and speak to why lost profits is not the right way to do it. Cost savings is also disfavored for a similar reason. It's too speculative. The courts have really, there's no case I've seen where they actually use it. It's at most used as a way, as a comparator. So it's a benchmark against which your royalty rate is measured to see if your royalty rate is totally out of sync with how much the government has saved from using 1498. The reasonable royalty method is the preferred method. And that sort of aligns with the legislative and historical record of 1498. You want to give the patent holder a reasonable compensation, compensate them for what you've taken, but not give them excessive compensation. And the best way to determine a reasonable royalty is to look at past licenses. So if, for example, Gilead had licensed out Sovaldi to another manufacturer, you'd look at that license and say, okay, well, they've already licensed it at this price, that's the price the government is going to get. But of course, pharmaceutical companies rarely license their new patents on profitable technology. So there's really very rarely a good benchmark license against which to base a reasonable royalty for government. So in that case, what the Court of Claims has to do is determine what a royalty should be based on something called the Georgia-Pacific factors. Now, I'm not going to go through these, and they're small for a reason. There's a lot of them, and they range from everything from the duration of the patent to the patentee's share of the market to opinion of expert testimony. But as you can imagine, they've been criticized, these Georgia-Pacific factors, because they're supposed to bring you to an objective royalty rate, and it's very hard to create an objective assessment of what royalty should be from 15 factors. And these are some of Judge Posner's sort of pointed criticisms of the 15 Georgia-Pacific factors. But in some ways, the breadth of the Georgia-Pacific factors and the fact that there's no real strict way in which they have to be weighed against each other works in our favor in this instance, because really they open up determining what reasonable compensation should be to good logical policy arguments. And the Federal Circuit recently recognized that the determination of a reasonable royalty really is so case-specific and so fact-specific that they're willing to let the patentee and the government come in with just sound policy arguments, common sense, logic, and argue this is what the royalty should be based on what we know and what we're trying to do here with the royalty and with using the invention in the first place. So in our paper, we sort of advocate for a method of calculating royalties that would be a mixture of looking at what the actual cost of developing the drug would be, as well as compensating the patent holder with a reasonable profit for the risk they've taken in coming forward with that invention. And we relied on an old case called the SONA to basically support the idea that you can actually look at the development costs of an invention in determining what the royalty should be, as well as what a reasonable profit in that industry would be. And you can use expert testimony or even agency guidance to determine what profits should be. This is sort of the last slide I have, and I just want to leave it open here that, even though it's very open-ended what a reasonable royalty can be, and that sort of throws us out into the open and can be a little bit scary, it also really works to our advantage in terms of allowing us to shape what we think a reasonable compensation for use of Sovaldi or Harvoni should be.
Thank you. That was a terrific presentation, Hannah. And I want to see whether Professor Kapczynski, because I know she's going to have to step out in a minute, wants to add anything to that discussion.
Thanks. No, I mean, I think that was a very skillful sort of summary of the most important things that we considered and found in our exploration of it. I think I would just stress that there is this history of having used this before, and so that is something that I think should be better reflected in the policy conversations about this. As Hannah mentioned, I think we were quite ourselves convinced at the outset of this that it had never been used in this area and only threatened in the Cipro context. So, so those old cases I think are quite useful and valuable. And I think, as Hannah also mentioned, the really critical question about its use going forward we think is how the damages ought to be calculated. So I'm very appreciative that you brought some excellent people here together to sort of add their own thoughts about the way that, this might be actually implemented, and so how, cover royalties might be calculated, because obviously the more specific we get about a particular instance, the better we might be able to get our hands around that. So I'll just say that. And I do apologize, I do have to go and teach a class for a few hours very shortly, and then I'll be back for the tail end of your discussions.
Great. Thank you. It looks like we're joined by Professor Conte from the University of Chicago. Can you hear us?
Yes. Can you hear me?
Yes. Great. Welcome.
Great.
So I want to open up and see if there are any questions for Hannah Brennan on her presentation. Sure.
So thank you. That was so fascinating. I have so many questions. I'll stick with one for now. Do we know anything about the role of the FDA in the 1950s and 60s uses of the law? And the reason I ask is that, as you said, we've had a number of changes in the law since then. We didn't have to deal with exclusivity periods in the 50s and 60s, but we also didn't have a defined and a pathway to the degree that we do today. So I'm just wondering if we know anything about that and can learn from that. Personally, I would like to know.
Yeah, the regulatory framework for getting approval of generic drugs was just so different that it was, in a lot of ways, a lot easier back then in terms of use of 1498. But, there should be new ways in which to get on, and I think that since the FDA controls that now, if you can sort of have cooperation between the different health agencies of government, there should be a comparable way to sort of get generics onto the market for 1498. And we explore that a little bit, but I think that it's hard to compare the past examples of how those generics came on just because the regulatory framework was completely changed after the Waxman amendments.
Let me ask you a question. Do you have a sense of how unsettled the law is when 1498 is used now? Is it pretty straightforward for the government to figure out what to pay, or is it constantly winding up in litigation?
No, I think the chart that I showed before of how often it's used, there's not that many 1498 cases, and there's a lot of use of 1498. So presumably there's a lot of cases just settling where it's routinely used, and I'm sure that there's a lot of patent holders in the defense area that this is a more normalized pathway where they're used to the government using their 1498 to procure technologies, and they work out settlements of how much the reasonable royalty should be without any issue. The real case law comes when it's unclear whether the use is for the government or not, and then you fight about everything. But in terms of reasonable royalty, honestly, it's so up in the air depending on if there are other licenses in that field, if there are comparable similar licenses, if how old the patent is. It's so fact specific that it's hard to really look at past examples and gain any real good teachings for this specific case.
But I was just trying to figure out whether it's just they've settled into any patterns, and it sounds like they probably have in some cases.
Right.
Once they do a few of them, probably the other ones know what the amount's going to be. Looks like we're joined by Dr. Kesselheim. Aaron, can you hear us?
Yes, I can.
Great. Other questions for Hannah Brennan? Yes. Go ahead. Why don't we go down the line? We'll start with Dr. Sen.
Okay. Yeah, I should follow up to Josh's question. So I didn't know that it's used so frequently and by other agencies. Have those agencies come up with some sort of guiding principles or criteria about when it's used that we could potentially draw on to say that this is used regularly, and here are some sort of guidelines for how it's used?
Yeah, I think that's a really interesting question, and I actually don't have a good answer to it, but I suspect that there is an answer that is, yes, they've come up with a way that they work this out, and it would be really interesting to interview some of those agencies and see how it's been done in those agencies and sort of what patterns they've fallen into in terms of using it effectively. But I think that's a good question. I think there probably is a fair amount of teaching that we can take from other agencies in terms of using it.
Okay, yeah, just in terms of even if they're not written out, but sort of how it's progressed and sort of generally seen as acceptable to use.
Yeah, definitely.
Yeah.
Great, Dr. Bach.
Well, I had two questions. I think the question about what it means to be for the government is something that we're going to get to later, so I won't ask that, I guess. But And again, I don't know how this relates, but I do know that Gilead has some sort of agreement with Mylan and has some sort of licensing agreement, I think, in India.
Yeah.
Which I assume has a royalty and things. Is that relevant, or maybe that's too in the weeds?
No, it's not. And if we had zoomed in on the Georgia Pacific factors, one of the Georgia Pacific factors is other licenses, and there's a case that mentions foreign licenses, and it says that foreign licenses are less instructive, just because Gilead will make the argument that they would never license it at the rate they license it in India to the United States in the United States market. So although we can look to that license for some information on manufacturing costs, I'm not sure that a court would really find the license that Gilead has given in India to be instructive for the US license.
Would the license from Emory that ultimately ended up in Gilead's hands, would the royalty payment on that be instructive?
I think probably they would look at that, yeah. Okay. I think that in a case like this where the construction of what a reasonable royalty would be is so novel, they'd look to everything they could and try to piece it together.
Professor Kapczynski, anything you want to say since you're still with us?
Yeah, no, I mean, I think that's probably, what Hannah said is exactly what I would have said about the India question, or the Indian licenses. Where there are license agreements, they do always get discussed, and I would say one of the patterns that comes out of the case law is that if there is a license, although with probably Hannah's amendment sort of in the relevant territory or in a comparable territory, those are quite influential to the courts. The bigger question, though, is what to do when the court discounts those, for example, because they're not seen as reflective of, in some sense, what the reasonable royalty rate is usually trying to get at is, sort of the bargain that the parties would strike. And so that's part of why the Indian example, for example, is not thought of as particularly instructive about what would happen in the U.S. market with respect to licensing. I would just say that, an amendment to that is that in this context, because this involves government use, and part of the purpose of Section 1498 is to ensure that the government isn't sort of held over a barrel by companies that have the ability to exclude the government. There's something even more artificial about the sort of idea of an arm's length market transaction, which is why I think we think that the courts are going to be inclined to have to ask some deeper questions about, like, what's the purpose of this government use provision? How can we ensure that everybody gets a fair deal out of this? And then probably look away from things like licenses abroad and towards the more critical questions like, what is the company invested? How can we ensure that the government's use of this isn't going to deeply disrupt innovation paradigms that currently exist?
Great. I want to follow up, though, on Dr. Boggs' question, which said later, just to get a little bit of it out now while we're talking about the history. If you could maybe give just a very broad overview of the types of the types of for government uses we're talking about, just to give a sense of the history.
Yeah. So there's basically two components to the for government use issue. It's for the government and with the authorization and consent of the government, and those two issues are treated separately. So for the government really means that you have to be manufacturing it. So say it's a good case on this that really helps illustrate what for the government means is there was a Japanese airline that was using a passport scanning technology, and they had no communication with the government that they were using this infringing passport scanning technology. And they got sued by the patent holder. And they said, but we're doing it for the government because the government requires us to scan people's passports so that they can get into the US. And even though they had never had any communication with the government, the court actually found that the use was for the government because they had to put into place that passport scanning technology in order to comply with federal law. So for the government just really means broadly is the infringing behavior on behalf of the government. The with authorization and consent of government is, did you get authorization and consent? And oftentimes that's built into a contract. So in our case, it would be built into a contract, or it would be built into a contract for the generic producer, but it would be with authorization and consent of the government through the communications. And oftentimes courts will look at letters between the government, between agencies and the manufacturers to sort of see if that prong has been met.
Great. Jeremy?
Oh, sure. I just wanted to follow up with, thanks for the talk, by the way. I've learned so much. I wanted to follow up on Rachel's question. You know, how is it that we have learned to forget that 1498 applies to pharmaceuticals when clearly there was such a robust practice? And I really enjoyed your cataloging of what may have changed. Sorry. I appreciate your cataloging of what may have changed. And yet when I look at that time period, right, the 50s and 60s, there really isn't such a thing as a generic drug industry then, right? There's sort of a different way of understanding. And so it strikes me that the point in time in which this is dissolving is exactly the point in time in which we are developing what we would consider the generic drug industry. And it's paradoxical. But so bringing up questions like ANDA and the new thresholds for approval of these markets, it's hard to understand. I'm interested in having you reflect a little bit more on what happens when we take a term like generic drug and put it back in the 50s at this moment, in the 60s, and then have that, our modern concept of the generic drug actually also being part of the problem of its implementation in the present. Yeah, oh, sorry. My microphone etiquette, but yes.
Yeah, that's a really good question. And I don't know historically as much about the generic drug industry in the 1950s and 60s as I would like to. I might almost punt this. Oh, did Amy already go? Okay. She might know more about this than I do, but yeah, I mean.
Jeremy, is there a book you could recommend?
But a different way to frame the question would be just so we look at forgetting it. Sometimes things just slip out of our framework, and now you're helping bring it back in, right? On the other hand, there's a question sometimes that there are structures that actively lead to that forgetting, and that's what I'm wondering.
I mean, I tend to think that a big part of the forgetting was a change in how we view intellectual property rights and the importance of intellectual property rights to the American economy. I think that the American economy is now so dependent on technology that we protect, and this can be seen through our trade agreements, we protect technology and we protect patents in a way that we didn't used to, because it didn't used to be that it was like our #1 export. And so I think that has given rise to seeing patents as more difficult to take, more precious, something that people feel less comfortable with the government just using. And I think that might have something to do with why there would be a bigger outcry now, it seems, than in the 1950s when it was just more routinely used. Also, just because of the growth of both sectors of the pharmaceutical industry. As you mentioned, I mean, the generic drug industry is totally different than it used to be, and the generic drug industry now and the branded pharmaceutical industry are such repeat players. There's more of an entrenched relationship now than perhaps there used to be. I don't know if that's true, but I think that could have something to do with it.
And it seems historically that the use of 1498 dropped well in advance of the Hatch-Waxman Act. So that so that may be multiple things involved.
I had a quick question. So with in the drug development side, the use of licensing and royalty agreements it seems to me pretty popular as a way to finance drug development.
Right.
Is that just too much of a different animal when you start talking about established or already commercialized product, or is there any instructive, relevance in that area?
I would definitely say it's relevant, and in our paper we basically argue that it's relevant for calculating R&D costs and sort of showing how much it costs to sort of create this drug and get it to the point where it's at. But when you look at royalty rates, they're very different depending on the stage the drug is in. So drugs at the stage that Sovaldi and Havarti are now in are rarely licensed, and if they are, it's at a much higher rate than the initial drug. So these are all factors where the court will say, oh, it's not comparable. It's not comparable to have the licensed pre-clinical trial to post-clinical trial.
And
but they'll still be used.
Another quick question. In other industries like telecommunications, you have industry players establish what they consider, fair and reasonable use of their patents as a way of setting technology and setting fringe royalty rates, etc. Is that any form instructive in the pharmaceutical? Is just technology is just again the prey animal?
I think it should be. I think the FRAND issue is really interesting. I think that it would be interesting to see if there could be an equivalent in the pharmaceutical industry, and that that might be a good framework to look at when deciding the 1498 question. The concepts are almost sort of there's a nice parallel between the two, and I think that studying the FRAND sort of issue would be helpful in the 1498 context.
Great. Professor Conte, Professor Kesselheim, either of you have questions? Feel free to signal. Nope.
Good.
They're good? Okay.
At this time, thank you.
Other questions? Okay.
So in the Bayer case with Cipro and Tommy Thompson, I understand he just mentioned it or something, so it wasn't clearly specified. But who was it putatively for, the supply of the drugs? Was it government employees or anyone who was exposed to anthrax or?
Yeah, I don't actually know. I think it was going to be first for government employees. But I think that, I think it was aimed at government workers. But I don't know the scope of what he intended when he mentioned it. And I'm sure that there was a lot of backroom talks after he said it out loud publicly about how far it would reach, and that all factored into what the price drop eventually was.
People actually died. I mean,
Cipro?
how many did they essentially buy at the end? You know?
Oh.
I don't think.
They bought for the strategic national stockpile.
But I mean, did they buy 20 million?
They bought lots of Cipro.
Right, but so way more than what you would.
They bought more than I think the number of federal government employees.
Yeah, that's what I meant.
Then that's your answer.
It was a strategic. There's this 72-hour deployment to any place in the country. There are these people. All they do is worry about how to move the strategic national stockpile around, and it includes Cipro, I think, as well as some of the other medicines.
So it's for the general public as opposed to just government workers.
I think the strategic national stockpile, which is what was eventually purchased, I think, that is the case. I don't know exactly, like Hannah's saying, when 1498 was invoked, what the reference was, but I know that there's a lot more Cipro purchased by the federal government than just federal employees.
I have another question about potential comparable licenses. Is there anything that we can learn from the Merck-Gilead patent dispute and the set of a royalty there by a jury, but in a willful case, about what a court might do in this case?
Yeah, I definitely think so. I think that they will for sure look at that and look at sort of the percentage of the market, and the court will grasp for any license out there, because always they want to compare, they want to create a license based off of what already exists instead of just pulling something from thin air. It's easier for them, but that's partly why, as Amy mentioned, sometimes it's better to think of a whole new way of setting reasonable royalties, because these things aren't really that comparable, and you're just sort of grasping at straws. And it might be better just to create a more holistic way to think about royalties.
So I'm going to use that question and transition to our next discussion, but I want to ask you a question first, and then we'll get to that, which is when we're talking about using this for particularly people in Louisiana that Dr. Gee is worried about, we're not talking about people who have private insurance that would be able to pay the full rate. And so a licensing agreement that would be for the private market might be inapplicable in a way to this population. In fact, you can look at some of the pricing documents that have come out as a result of Senate investigations, and you could see that there's an understanding that the actual market of people who can afford the medicine is much smaller than the total number of people who have the drug. And if you use the kind of but-for formulation, then they're just not going to get it. It's not that somebody's going to be paying $20,000 or $30,000 or $40,000 per course. Do you think those sorts of factors would be relevant to a discussion of the appropriate compensation?
Yeah, I do. And I mean, I think it's relevant insofar as it forces the court to reach outside just the classic Georgia Pacific factors. I was glad Amy mentioned this. I mean, the Georgia Pacific exercise is basically, let's pretend we actually wanted to license it. What rate would I license it to you for if I wanted to? And that fallacy is particularly bad in the 1498 context, because the whole point of 1498 is that the patent holder does not want a license. So as you're saying, the fact that the license goes to a population that would never be in the position to negotiate for a royalty payment, I think should be considered and sort of go into what it means for the royalty amount to be reasonable.
Great. I think that's a good transition point maybe to the next discussion, which is the appropriate principles for the use of 1498. And let me just back off for a second and just point out that Dr. Gee asked us to address certain questions. And one of them was the history, which we got a terrific history lesson just now. The next one is appropriate principles for the use of voluntary licensing in Section 1498 to address public health challenges. Number 3 was key considerations. And we're going to be talking later about the legal and economic considerations, and then lastly to make recommendations to her. So with that in mind, we're going to jump into the question of appropriate principles. And I think we have the slides up here, and I'm going to lead this part of the discussion. And really what we're talking about is using Section 1498 in this area where the federal government would arrange with a manufacturer to make one of these highly effective hepatitis treatments, and then compensate the patent holder for that use. And so the government would be basically paying for the medication from essentially what might look like a generic company, and then paying the patent holder some reasonable compensation based on the discussion we had and we will have. Why not just, the first question I would have here is, why not let the law just dictate when that can be used? In other words, why have any policy principles at all for that? Should it just be used when it can be used? And I think the first threshold question is, why are we, thinking of this as a special type of authority that in the setting of pharmaceuticals should be used with care, as opposed to just whenever we can? And my view is that we're here at a public health school considering this question, and we got this question from Dr. Gee, who's a public health official, because it is important to think about the public health dimension of why 1498 would be used. And I think Amy Kipczynski mentioned that something that we all realize, that the purpose here is not just to figure out how to get any particular medicine at a lower price. The purpose, the reason why we would think about using something that is pretty dramatically different from usual drug pricing is because it can help us solve a problem. And so the first principle, I think, would be, the first concept is that we would want to use 1498 in certain situations where we think that there is real value for solving a problem, and not just using it for the sole purpose of reducing a price for a particular patient. But I want to pause here and just see what you all think about that basic supposition before we get into what principles might actually be there. That you could certainly take the position that, well, the government can buy it, then, then the sky's the limit, the formulary is the limit, and we should just be doing this. That list of examples could be quite long for pharmaceuticals. Why should we think about putting boundaries on that in the first place? Any thoughts on that before we move into some ideas about what principles might be?
It seems like it's a very unique United States question, because essentially in the UK or any place else, it wouldn't be an issue. They would just buy it at, with the government set rate. So, it does strike me as a very U.S. specific question, that we would only do it in certain circumstances.
Well, that's partly why I'm asking that question. Yeah.
So something we thought about was, how does it change the drug market? If you have the government taking patents on a certain type of drug all the time, does it funnel drug manufacturers towards researching a certain type of drug. For example, if they know that the government is less likely to take patents on statins, do they just all start investing on making more statins? I think a real key concern is how does it shape the behavior of research and development?
I think that's an interesting point. Are people hearing me?
Yes.
Oh yeah. So I mean, actually, to Jerry's point, do we actually see other countries using this sort of model to obtain hepatitis C drugs for their patients? I mean, no. I think what we actually see is that they end up negotiating and for or at least early on, the prices that they were getting for the hepatitis C drugs weren't that much lower than in the U.S. because of the patents that the company had on the product and the at least goal of these countries to try to uphold intellectual property law and patent law. And I think it's a balancing act. And I think that maybe what we've seen is that after a certain amount of time in this one particular drug, given how effective it works in the sort of public health scourge of the disease, maybe this very excessive step of intervening in this case may be warranted. So I think those to me are the kinds of considerations.
Great. Peter?
I'm not an expert on this issue of what's happened with licensing in other countries, but I'm not sure my impression is, at least I wouldn't characterize it the way you did. In, for example, the UK or most of Western Europe, I'm not aware that the governments have simply taken product and given whatever
I agree.
And they will close formulary, they'll do other things. It's often talked about that the threat on the back end of their negotiations is a compulsory license action. I think those are very rare or maybe non-existent in the sort of, if you will, fully developed Western world. There are examples of countries doing this, India, China, Colombia with Gleevec, I think, where they've, used compulsory licensing, but I use that term not fully aware of what the difference is between compulsory and voluntary. But I actually think, the earlier question is, the market predictability is one of the challenges, and one of the reasons I think to be, if this kind of action, to be clear, send clear signals to the market that could be relied upon, so that they don't, take statins again as an example, but instead that the government just decides like every time there's a statin, they're just going to take it, that would seriously alter the calculus for developing another statin. Right. In the case of statins, we might be fine, but it would matter a lot if you took a disease category like communicable disease and said, that's it. These are public health problems. We're taking these.
The one thing. So
let me just add a couple of wrinkles to it. One is, I think there's a couple dimensions of it. Right? What clear signal of category is one. Another is what is the target population. I think, if it's federal employees, whatever, that's a couple million. That's at the beginning of this administration. That number will dwindle. So maybe that's a rounding error. And then you also have to think of it within the context of all of these other government mandatory discount programs and how those all interweave, because there's Medicaid and there's 340B, VA has mandatory discounts. And I just think that it sending clarity to the market around, this is why this is an unusual case. These are the features of it. Cancer drugs are not on the docket for next week, or maybe they are, but just so that people sort of know.
Right.
Great. I was just going to clarify one thing, and then I'll move forward. I certainly think the point Jerry was making, I think, is that other countries use many more forceful tools than the United States does around drug pricing. So, but this particular tool, I think your point is well taken. It isn't necessarily used very frequently by other countries, and I think partly that's because when you're dealing with intellectual property, it creates concerns about the market, and I think the one reason to have principles is that you're really using it when it should be used, and you're able to be thoughtful about each individual one rather than try to solve everything or try to go after everything at once. I would say, though, that I don't necessarily, and we'll get to this because we should have some principles about the pricing as well, except the idea that we're taking it is assuming that it is a significant harm to the company because we're giving them reasonable compensation. So I wouldn't say that, if this tool is used in a vindictive, expropriative way, then that would send one signal. But an important aspect to the signal is whether it's being used appropriately and fairly. And so the principles around use in that way would be important. Rachel, is there something you want to add?
I just want to add a little bit to that. I think about sometimes the use of 1498 in the United States as being a tool for intra-country differential pricing in a way. So this is a segment of the market that is not currently being served for various reasons. And so when we think about tiered pricing in the global health context, we think of it as a win-win, right? The company can make money that it would not have otherwise made, and people get access. So I understand that that's not
exactly
the way in which
the point I'm
everyone would
making.
frame
That's
it,
exactly the point I'm making.
but
Yeah. But said better than I was making it. Yeah.
Said differently.
Yeah. So I do think as we get into it, we're not just thinking about the principles about when to use it, but how to use it. And so why don't we go back to the slides then?
So I have a, Josh, I have a comment about this in follow-up to Rachel's, which is, I think that the key here is invoking the price, but also invoking quantity commitments. That we want to be able to assure the market, which includes the manufacturer, but also the public, that we are invoking this type of activity in order to address very specific health needs, and we intend to make good on the promise to the public that we actually want to address those public health needs with a quantity commitment.
Great. That's a great point, and it's going to lead right into the next discussion. So the second question then would be, if I can get this to advance. Let's see. Can you advance it one, perhaps? There we go. Which principles should we consider? And so here are a couple topics. Go to the next one. The number of people affected, the severity of the condition, the scale of the financial barrier. And I'm going to show you a little bit more, and then we'll have plenty of time for conversation. So why do I think these are relevant? I think that the purpose, a particular purpose for the government to use something is to solve a problem that really rises to the level of the government and not an individual single person in the most obvious sense. And so significant problems that cannot be solved that affect many people would be your best case for using 1498. That's the basic starting point here. And I think that's why we're sitting here, because we have hepatitis C in Louisiana as a very serious disease that affects thousands of patients, many thousands of patients, and is essentially, the scale of the financial barrier is unmanageable for the state. So I think if you started there, you'd say, well, we're going to use an extraordinary authority when we have this kind of major problem. Let me just say other kinds of principles, because we've already started getting into them. And so Conte was speaking about the first one here, which is other principles that you could apply to the use of 1498 is that even within a major public health problem, we're not just trying to get a few people to medicine, we're actually trying to address the public health problem. And so you would see a commitment to making the product available to the people who need it, including non-pharmaceutical components of such a strategy. And then my next bullet here relates to this issue of reasonable return, that you would actually have to be implementing it in a way that did not take away the ability of a company to make a reasonable return in the big picture for the investment that it made. There should be transparency about the use of 1498. Shouldn't be done in secret. People should know how it's being used. That there should be engagement with industry. I'm putting them all out rather than going one at a time here. Just these are the things that I've thought about, that it shouldn't be something that a company reads about in the Pharmaceutical Times or whatever major newspaper or a proprietary newsletter they're reading, but that they hear about it and they have a chance to work with the government, maybe initially around a voluntary agreement that could be done without having to invoke 1498. And that alternatives are considered, which may be, in certain circumstances, the use of other available medicines, for example, that you're trying to basically use 1498 and the authority that it brings when it's really necessary to address a public health problem, and you're bringing along with it a commitment to addressing that problem. So let me pause for questions and comments on any of these. I also have my last question, which is what other principles should be considered. So we have a range of different topics. But I think the idea, let me put this in a different way. One of the issues that I thought Hannah brought out really well in her presentation about why this hasn't been used that much is that people, the whole concept is very daunting. And the idea is if you're in for one toe, you have to jump in the whole pool. And one of the ways to take this from being such a daunting project to something that is much more manageable in the way we think about it is to set boundaries on it, boundaries that may not be required by the law, but may be required, but maybe make sense for policy, and to say these are the examples. We want there to be reasonable return, but we also want people with hepatitis C to get treated, and we also want to be able to address a major public health problem. And so if we were going to take that approach, what are the kinds of things of this list or others that we would apply to an appropriate approach to 1498 that might take it from something that's quite powerful but never used to, still powerful but used much more judiciously. So, okay, Jeremy.
So one question just to, I think these are very reasonable approaches. Something I don't see mentioned on the list yet is the essentiality of the medicine or the lack of available alternatives. And I just want to put this out there as something that is certainly very apropos to the case in Louisiana. It might help us extend in principle where not only is there a public health impact, but it requires the medication, and there is not a satisfactory alternative that could be turned to.
So he has severity of condition, and I wondered sort of, is that covered or no?
I think severity of condition is important, but you can have a severe condition that could be treated by 3 or 4 different agents.
I have consideration of alternatives, but I think we need to tighten that a little bit. I think that's a great point.
So I don't know, just hearkening back to Hannah's story about Secretary Thompson and Cipro, sounds like they didn't do a lot of this. It just was like, what do you mean you're not going to sell it to us? We're going to use 1498. That brought the Cipro manufacturer to the table and the problem got solved. So I guess I think that I would also want to emphasize the possibility that somebody could kind of take all of these very thoughtful, deliberative points and kind of play the long game out with them. And while we are considering all of these things, that we could also be acting at the same time.
Excellent. Nobody expects the Harlem Globetrotters. Right? That is a
really good point. That happens.
Yeah. So I think let's take the Cipro example. If you go back to the principles that I had out there, it's a lot of people were involved in that. It was pretty important from a public health perspective. There weren't perceived, satisfactory alternatives. So I don't think we're trying to make it a big deliberation every time. I think we're just trying to point the use of this tool in a particular direction that really makes sense. And so I think the Cipro use is probably pretty relevant. And in fact, it suggests also that, if there's an emergency, that may also favor using a tool like this rather than trying to go through a more deliberate message.
Would you have times when you wouldn't use it? You're sort of stating the affirmative here. Is there things where you would say to the industry, we probably wouldn't use it in these cases? Or do you not want to go there?
No, I'll let that question sit out there. But I personally, I think there'd be certain types of very unique therapies that I think would be wouldn't meet very many of these criteria.
So many of the orphan drugs wouldn't.
Orphan drugs that you get, as we know, a little bit
The
complex.
real orphan drug is not the fake orphan drugs, but yeah.
I think all of us know that it's extremely important for the pharmaceutical industry to get a return on its investment for key therapies. And so I think, to me, it's a bit of a picture. I could list off 10 ways I wouldn't think would be good uses of this. But I think the idea here is we want to be very thoughtful about when we would use it, that it would be used in an exceptional way when we had something that really resonated on these kinds of criteria.
So was partially to you and partially to Hannah. I mean, would, in a legal sense, you know, to say this wouldn't be used in these things give you more stature for saying it's appropriate here, or is that just irrelevant?
Well, one thing I mentioned, and I didn't sort of flesh out in the slides, is you could have agency guidance on when this would and would not be used. And I think that would help calm the courts when they hear these cases. I think that it's important that the courts, Dr. Bach mentioned this, feel like there's predictability and there's guidelines and there's barriers. So I think that having some sort of guidance of this, it's going to be used, we're considering it in these circumstances, not in these circumstances, would make the courts feel like it was more cabined and more reasonable. Yeah.
So might be helpful. Yes, Rachel.
I just wanted to follow up on Hannah's point and say that the process for setting the principles is also important. So to the degree that there's maybe a semi-open process for setting them, at which there can be input from different stakeholders about what's critical here. And then I think it might be important that whatever principles are developed are relatively invariant. So if they can be changed on a whim by a secretary or a commissioner or someone else, then there's not really the certainty for industry that we would like or that we've been discussing. So maybe some sort of notice and comment rulemaking to get a little more practical or something like that could be useful.
So, yes.
I'm sorry. I'm a little, I think I'm confused. I guess if I think I'm confused, that means I am. I thought that, based on your initial presentation, that there wasn't much question about the authority and the ability for the government to use it, and that the dimensions of the question that were more challenging were around what it means for use by the federal government, which obviously leads me to wonder, like, which patients are we talking about? Is this Medicare, Medicaid, what? VA, I don't know. I mean, it seems like federal employees is a straightforward shot. But I thought that when you talk about the courts and how they would deal with it, I didn't perceive, and again, I'm not a lawyer, I didn't perceive a meaningful threat to the very notion of the government using it. I was thinking more from a policy perspective, the implications of the government using it. And then I understand that there's some issue about, like, what would the payment be, which is obviously complicated and super important. But your question seemed to suggest to me that you think that the viability of the approach from a legal perspective in the first instance was questionable.
We've fallen into a little bit of a trap of turning a policy discussion into a legal discussion. I had no interest in my section here of talking too much about the law.
Okay.
I think I'm really talking about whether it's a good idea to have standards that go beyond the law. And so we're not trying in this word, because you could say, well, we're just going to use it whenever we can, But I'm saying, that there's some reasons why I think that wouldn't be the best policy. And a better policy would be to limit it in a way. We kind of veered into the legal territory when it was like, well, actually, if you limited it a little, that might strengthen the legal case in some regards. But to me, that's immaterial for this purpose. I think it's really like, if we are going to think about what the best case is for using this, in my mind, it's like, look, we support the patent system. We support reasonable return from companies. We have public health problems that need to be solved. We have people dying of essentially a disease that can be treated, and only because the price is too high. We need to figure out how to work through these, and on these unique situations, we're ready to use a pretty extraordinary, for this modern day legal authority for pharmaceuticals, because we think it's really going to help. And we're going to bring that in because, I think that it has the effect of clarity, certainly, for the industry. I think it has the effect for why we would do something that may not, may seem to be a little bit jarring to the American ear about drug pricing. I do think that we should maybe take a half a step back and think about the National Academy of Medicine recommendation. The National Academy of Medicine is looking at the elimination of hepatitis C as a public health problem in the United States. And they basically concluded that standard pricing won't work. And you also have the companies pricing their products where they know the vast majority of people with the disease won't get it. So you have the companies not expecting to pay for it. Peter recently wrote about a very extreme example of this, which I'll ask him to explain. But the companies are not thinking that they're going to be able to treat everyone. The National Academy of Medicine doesn't think it's feasible under current pricing arrangements, and the market doesn't either. And I think, Peter, your recent thought experiment is relevant. I don't know if you want to explain that here.
Oh, sure. So it pertains to Hep C yet again. We actually, a colleague of mine at MIT, Mark Trusheim, and I went through the process of trying to figure out what would happen if the federal government actually bought Gilead from its shareholders. And there's a process for doing this. It's a public company. You can go in and essentially offer the shareholders a price for the company that's on average about 30% above what it's priced at today on the market. And we went through that and then asked the question, if you were the government and did this, and then sold off all the aspects of Gilead that didn't pertain to the U.S. Hep C market, how much would you be left with? And how many people could you treat with Hep C for that compared to how many can you treat currently? And the answer was about 3 times as many people. You came in about $13,000 per treatment course through this math, which assumed paying the shareholders a reasonable return that any other investor would have to pay them in order for them to sell the company. And the implication is not that there's a bargain hiding that nobody else has seen, right? Because Wall Street's pretty savvy on these things. The implication is Wall Street doesn't expect Gilead to successfully sell this product in the U.S. to a point where they dent the public health problem. And that's based on the reality that Gilead is not doing that, and neither is Merck or AbbVie. In fact, new starts for Hep C treatments are declining, even though the prevalence right now is probably about 2.7 million, probably only treated about 600,000. So investors and the company both know that they're on the back end of this business, even though from a public health perspective, you've gotten virtually nowhere. And that's why you get this sort of arbitrage opportunity. Right. So, and it's actually, we were completely serious that this was a very reasonable use of federal resources. It's a different way of getting the product, if you will. It covers the whole U.S. that way.
So I think that thank you for explaining that. And I think what that shows is that we're dealing with something very specific, a specific kind of scenario here, where we have a tremendous public health need. It's pretty broad, it's very serious, and nobody is expecting, to the point of what's the but for, nobody is expecting that people are going to be paying market prices to make this available. And that, to me, may be a particularly good kind of set of circumstances for using 1498. Maybe not the exclusive set, but I think it's even among these various conditions. If we set the condition for very common, very serious, no reasonable alternatives, a fair process, all these different things, you might even add in there that nobody, as the kind of the final factor, that there is no expectation really that this medicine is going to be available to treat these people in another way. And so that is really the situation. And you can see that from these various vantage points, including the very interesting thought experiment that I know you think of as potentially more than a thought experiment. Aditi, did you, Jim?
Yeah. So, it seems to me that there's you could use it when there's a misalignment of incentives. Whenever the private firm, they want to maximize their profit, and not to be cynical, but yeah, Gilead's not going to sell 3 million doses of Harvoni tomorrow because next year they won't have any of the revenue from it. Maybe when there's 3 months left on their patent, they might go out and charge $5,000 per treatment course. But it seems whenever there's a misalignment of incentives, and from the government's perspective, they would care about social welfare, consumer surplus, producer surplus, but from a producer's or from the pharma companies, they only care about their profits. So are we limiting it to, or it'd be helpful to limit the use of 1498 where there's a clear misalignment?
That's a very provocative statement. That what way of thinking about this, and as you know, there's a book that is out that is making that basic allegation that has gotten a fair amount of attention and controversy. But I think, personally, I don't think you need to get into motives around things to be successful in this. I think the idea that there's clearly no expectation on anyone's part that for whatever reason, I mean, it could be just that what appears to me reading the Senate documents is they were looking for a certain amount of revenue, and that led to a certain pricing, and it just happened that meant that the vast number of people wouldn't be covered. I don't think you have to look to the motives, but I do think that this particular set of circumstances is particularly instructive because there really isn't another way to solve this problem, I think. And I think what is really particularly relevant about the National Academy of Medicine is that they're looking at solving a national public health problem, and they can't find a conventional way to do it. And I mean, that in and of itself might be another exemplary criteria, that you have a group like the National Academy of Medicine looking at the problem and finding the failure of conventional pricing to be successful. Other comments or thoughts about that?
One more thing that's sort of come up through the discussion has sort of been mentioned is to look at how much of the population depends on the government to get their medications. So HCV is a particular example where there happens to be a lot of people who have HCV and are actually on government programs, whether it be through the VA, through the IHS, or through Medicaid and Medicare, or in the prisons. So, I mean, this is a particularly strong example of where the government is actually responsible for providing care to a large percentage of the population. And the only thing that worries me about putting that as a factor is that then do you get pharmaceutical companies not wanting to make drugs for people who are poor or dependent on the government for their health care?
Yeah, just to follow up on this, it does seem that the risks of tailoring a program such that we create a disincentive become more substantial the more that these rules tend to steer towards particular sectors, to particular kinds of people.
Again, I would just challenge you to say, like, we obviously want not to undercut the fundamental. We don't want to start with the assumption that this is really aversive.
Yeah.
In the end, like Rachel was saying, it can be thought of as tiered pricing for a group that is never going to otherwise have access. So.
And also a way to get money the government was never going to be the pharmaceutical company was never going to be making money off of this population. It never counted that it was going to get dollars from this population in the first place. So in some ways, it's getting money it already thought it was losing, or already thought it was never going to make.
Right. That's another way. I think that's sort of the set of circumstances I'm talking about. It's another. I think there are a couple other factors that are coming out. The failure of conventional pricing as recognized, and the fact that there's not an expectation that people who need under conventional pricing, that people will get treated. Peter?
Yeah, I mean, I get that principle, but I mean, there's a moral hazard, sort of a policy bent to moral hazard in there to some extent, because if you decide that you're going to then use the system in situations where the government wouldn't otherwise pay for medications, you've just created a relief valve for more constrained government spending. Right, so that if the government changed, for example, in Medicare, the government has to pay for every cancer drug for every indication. But under a situation where you have the ability to use 1498 for government programs, you could relax that requirement, which I'd be in favor of for other reasons, because you have 1498 on the back end, right? But then you would have the argument that, well, these people in these government programs wouldn't be getting these cancer medications otherwise. So it's the dynamic aspect. I get the point, and and this, the other side of this is that, this isn't, this may be, if you think about innovation incentives, this may be oriented in a way that has a sort of long-term drag effect. If you look at something like the treatments for Hep C and be like, look, they're fabulous. This is a really important problem. It's a one-time treatment for 90+% of people. Toxicity profile, as long as you don't have Hep B, is pretty good, right, or excellent. Really great medicine. We're lucky to have it, right? And that's where we're going to use 1498. You could be essentially signaling this sort of don't outperform an innovation, or you will, potentially have it. I mean, that's the challenge, right? Because if you look in the cancer drug space, I can list dozens of cancer drugs where you'd never do this because they cost a lot of money, but they barely help people, right? So you wouldn't sort of go to this trouble, but we don't want this, if you will, the safe zone for innovation to be there. And I'm not I mean, the broader issue, I think, is the counterbalancing of the narrow interests against the public interest. And I think that's a tougher one. But I think that's how I tend to look at this, is that this is just, my thought experiment is always like, what if there's only one company that had the IP for cleaning water for people? Would we really allow people? We probably would. I mean, but is it socially desirable to allow people to not have clean water to protect the intellectual property of the one company that has that?
Well, we had that case, and the court said, no, you have to clean the water. Sewage treatment plants can basically infringe as many patents as they want, because otherwise the public health effects are disastrous. So, in practice, the effects of denying an injunction are just the same as granting a compulsory license. It's just much more ad hoc.
And I think we're going to start to transition over to the next section, but I do think that it's for exactly the reasons you're talking about, that a key principle has to be that we are thinking about these issues and we're using it in a way, in a particular instance, that is not, fundamentally undermining the ability of companies to earn a reasonable return on their investment. And that gets to some of the, pricing questions, but I do think that it is a solvable problem because nobody was expecting the patients to be treated. That the fact that nobody was really expecting the patients to be treated under conventional pricing makes, including the company, by its own assessment of the market, and the market makes it not the case that we're, pulling the rug out from under the financial incentives to produce in the first place.
You haven't mentioned communicability as a principle. You also haven't mentioned the freeing up of livers in this case for other people, the sort of opportunity cost of not treating Hep C. Those are both positive spillover effects, if you will, if I'm, again, using an economic term I probably shouldn't be using. But I think those are issues that don't pertain to many treatments.
I think that's true, and I did not include. I think the concept of positive spillover effects being good is a good one to have. I don't personally feel like communicability is a necessity, because I think there are social externalities of a lot of other, positive social externalities of other types of treatments that could have a really important value. But I
agree. I like the tightness. I mean, it doesn't have to be communicability, but I like the tightness of those two dimensions of the positive externality. Obviously, everything, making people feel better has all sorts of hard to measure positive effects on others as well. But I actually think when you're looking for principles, I think it would be nice to have clearly articulated kind of, if you want to pursue that as a principle.
Yeah, that's good.
It would apply here. There's a lot of examples where it would not.
And I would go back to the legal side of this. Is that part of it, that those externalities are not in any of the law?
No, I wouldn't say so. Although, these things get brought up as a way to sway the court on policy arguments. So they would get sort of lumped into this category of, this is not a good idea because it's going to create this problem with the market. And courts do pay attention to those arguments.
So we're not, potentially, if we do a thoughtful job on the principles, it would be helpful potentially in court, which is a good transition over to our next topic. So I'll turn things over to Professor Sachs here.
The clicker?
Yeah.
Okay, great. I'll wait for it to go up. So in this presentation, I should start by saying that I'm really relying on some of the wonderful work that Hannah, Amy, and their co-authors did, and then I'm adding some additional legal considerations and concerns of my own. So these are the three questions I'll be addressing today. First, for which populations of patients in Louisiana would we be seeking to use 1498 authority? And then what additional existing federal laws, if any, would we need to invoke to extend the reach of 1498 to those state-based populations? Second, how would FDA-granted exclusivity periods complicate the analysis, and how can they be managed? And then third, when securing FDA approval of the generic product, can we expect any unique issues to arise during the approval process, and how might we plan for those? And that one's going to be really brief. And like the last couple of presentations, what I'm doing here is assuming that we're actually invoking 1498, not just threatening it and then reaching a negotiation with the manufacturer, because there might be different legal issues that would arise in that case. So for instance, Medicaid best price has come up. I don't think that applies if we actually invoke 1498, but I do think it applies in a voluntary patent buyout or negotiation situation. So I can talk about that in later if people want, but for now I'm assuming that we've actually invoked the law. So as lawyers, of course, we start with the statute, which we've already seen a couple of times today, right? And so this is the concern that we have when we're thinking about which populations we could be using the law for, right? The use needs to be both by or for the United States, and then when you're talking about third parties, it needs to be with the authorization or consent of the government. And so in their great paper, Hannah and Amy referred to these prongs as the government use test. And I think the fight here in the courts is really going to be on the first prong, because if you're in court where the government is actively defending its use of 1498 against the company who's seeking a royalty, presumably the government has authorized or consented to its use. And so the sort of question is a little bit more jurisdictional. Under what circumstances is the use for the United States? So there's three groups of people I think we are really interested in here in Louisiana, and this is increasing order of difficulty. For this slide, I'm going to stick with 1498 and make the case for it, and then on the next slide I'll talk about existing statutory authority that we might invoke in addition. So the first key population we want to use the authority for is presumably the state Medicaid program, especially in light of the restrictions we've all seen that have been placed on the use of the drug. And this is the easiest case of the three categories because there is significant federal involvement in the program. So I view this as much closer to the case of Medicare than to something like state correctional facilities, right? This is a program which is designed for the provision of access to care to these populations. And so although it's a cooperation between state and federal governments, the federal government sets a lot of the terms of engagement, right, including setting the rule that once Medicaid programs decide to cover prescription drugs at all, they have to cover essentially all of them and can't place undue limits on access. So I think in this case, it's fairly clear that use is for the United States based on the purposes of the program, based on the contracts between the state and federal government. And so all we need here is a procedural authorization, presumably from both Secretary Price and Administrator Verma, that it can be invoked here by the state and by private contractors who may administer the program in any particular situation. State correctional facilities and the uninsured are harder on the face of Section 1498. So just a note about the uninsured population in Louisiana, their rate has fallen quite significantly with the Medicaid expansion, down from 21.7% in 2013 down to 12.5% last year. And so that's great. That's still a lot of people, but the demographic makeup of that group may be different from states in which they have not expanded Medicaid. So maybe just a note for us as we think about the scalability of this procedure. So on the next slide, I will talk about other sources of law, but for now, I want to try to make the case both that use within state correctional facilities and for the uninsured is use for the United States, even in the absence of other authority, and I want to make the case that a court would hold as such. I don't think this is watertight, but I want to try to make sort of the best argument I can. And so recall that we're assuming here that the second prong is met, right? This is a case in which the federal government is supporting the use of 1498. We have their authorization or consent, and the question is just about use for the United States. And so substantively, I think there are two good reasons why it's met here, and these would be true to a greater or lesser extent for other conditions. So first, this is a classic communicable disease, as we talked about. It's in these areas where the public health authority of the government, both state and federal, is at its highest. And particularly in this case, this is more of a policy question, where we have a communicable disease that's connected, at least in some ways, to the opioid epidemic and to intravenous drug use, a topic of huge public health concern, I think it's difficult to argue that controlling this condition is not beneficial to the United States government. And then second, the federal government has a direct financial interest in the treatment of hepatitis C in particular. So many people who are currently in state correctional facilities will be eligible for Medicaid upon their release. And at that point, the financial interest will attach, or they will be eligible for Medicare later in their lives. And then the federal government has an interest in reducing the amount it spends through Medicare and Medicaid on treating these patients, not only for Hep C, but also the associated health problems, some of which have come up already. So if that cost can be borne by the state now, the federal government should prefer that. I also do think that if the federal government is behind the use of 1498 in this context, the courts will probably go along with it. So Hannah, you had a note in your paper saying that the Federal Circuit tends to align itself with the government's view as to whether it benefits from the conduct or not. And so I could see the court going along with it here. And so I can't be certain exactly what they would do, but I think the argument is fairly strong. But especially in the case of state correctional facilities, there are other sources of law which make the case a little easier to make. So the federal government does have an obligation to ensure that certain standards are met whenever people are imprisoned, including under state authority. And there's two sort of sources of law here. First, the Civil Rights of Institutionalized Persons Act of 1980 gives the Department of Justice the authority to enforce the rights of people who are incarcerated in state and local facilities. And so the statute 42 U.S.C. 1997A says, whenever the Attorney General has, quote, reasonable cause to believe, unquote, that the state is subjecting persons to, quote, egregious or flagrant conditions, blah, 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 the Attorney General can institute a civil action trying to demonstrate that and providing for remedies. I also wanted to bring up the 340B program as being relevant to both state correctional facilities and the uninsured possibly. So 340B is, for those of you who don't know, is a little bit flipped from normally what we think about. It's not a program about people, it's a program about facilities. So it allows certain healthcare organizations to buy drugs for their patients at significant discounts. And the list of organizations entitled to purchase drugs through 340B was expanded in the ACA. On its face, it does not include prisons, or correctional facilities, but some correctional facilities have figured out how to use 340B to provide medicines for their inmates. So if you have, for instance, a critical access hospital and the clinic at which the hospital provides healthcare services also serves incarcerated persons, then the clinic is eligible for the 340B program. And remember, this is a federal program that's designed to provide health insurance. So to the degree that Medicaid gets in pretty easily under 1498, so does the 340B program, in my opinion. And relatedly, I know that federally qualified health facilities provide care under the 340B program as well. And so if you had some number of uninsured people going to those facilities, it might be that they were able to be reached in that way as well. And then finally, I did want to float the idea of using Medicaid waivers to get at some of the uninsured population. I know both in the National Academy's report and in the paper that Hannah and Amy have written, there's a suggestion that sort of a first best program would be for Congress to create a program like the Ryan White HIV/AIDS program, but I'm trying to avoid Congress here, assuming that they will do something. So I'm going to suggest that particular states might be able to do something like this through Medicaid waivers. Such waivers do have to be budget neutral to the federal government, but the savings don't have to be contemporaneous. And so there's precedent for using 1115 waivers to expand HIV care or family planning care, concluding that these services will sort of pay for themselves over time, where we have particular math that allows us to say when people live longer, it's not a cost to the government, that's a benefit. So that's another possibility. So moving on to the second question, even if we can invoke 1498, and I think we can, I think the case is strong, we've got a couple of FDA situations to work through, and the first is this question about exclusivity periods. And so remember that we're only here if we're trying to get a new generic product approved. And if we are, the problem is that all of these drugs have a 5-year period of new chemical entity exclusivity granted under the Hatch-Waxman Act. So even if we can get around the patents, we have to figure out what to do here. And Aaron, you may remember having a conversation with me about a year ago about this. So now here's the slide. It does matter here a little bit which product we choose. So Gilead's exclusivity period for Sovaldi expires December 6, 2018, versus Harvoni, October 10th, 2019. AbbVie's after that, Merck is after that. And so the best thing would be if we could file a paragraph 4 certification that the generic product that we have decided to go with and move forward with doesn't infringe the relevant patents. And if that's true, then we can file a generic application 1 year before the expiration of the exclusivity period. And so that would mean this December for Sovaldi. And then under GDUFA, we're talking about something like it would be approved roughly around the time that the exclusivity period expires, because we do have to consider that. And so we could have a product approved and ready to go at the end of the exclusivity period if we didn't want to break it. I should say that I'm not completely sure what it would mean to file a paragraph 4 application here, because we've said that the government has a compulsory license, basically, but we haven't eliminated the patent, right? It still exists in the private market. So I am not sure that it makes sense to say that the new generic doesn't infringe the patent. It's just that the infringement isn't actionable. And there's plenty of cases in the statute where that situation is contemplated. So I would love the advice of Hannah or Aaron or other lawyers on that particular point. But, and I think the third bullet is key here, we may not even have to go down that route, because remember that I'm assuming we're working with a motivated administration who wants to actually invoke 1498. And so if it's true, then a motivated FDA commissioner could do a lot here. So it's possible that we file maybe not an ANDA, but a regular NDA, and the commissioner approves the drug on the basis of a non-inferiority trial or on the basis of public studies, maybe in the way that was done sort of with the colchicine context. An alternative possibility is that we end up in a McKenna-style situation in which the commissioner decides to exercise enforcement discretion and allow the generic on the market. And these each come with their pros and cons, but they are possibilities if the government is really truly behind this use of 1498. And then finally, I just want to raise this because I think it's always best to plan for pharmaceutical company gamesmanship. I'm not sure how likely any of these actually are, but the reason I'm raising them now is that I think it's very, very easy to prevent any of these from happening as long as we negotiate the 1498 settlement agreement to prevent them. So there are different ways in which pharmaceutical companies, branded companies, try to game the system and delay generic entry. One is by filing citizen petitions saying that the generic application is deficient for some sort of reason, and almost all of these are denied, but they do serve to delay the process. Similarly, a number of companies have adopted closed distribution systems where they have the effect, if not the purpose, of making it more difficult for generic companies to do bioequivalence testing. And then finally, there are some abusive Orange Book tactics. I think all I want to say here is that we can provide for particular clauses in the settlement agreement after 1498 where we say, with a closed distribution system, the company shall make available on non-discriminatory terms enough of the product to enable these studies to be done. So I think, these are not real concerns that we should worry about in practice as long as we think ahead and plan during the litigation process, which we do have to go through, as we've talked about. So with that, I'll take questions. There's a lot here. You guys should yell at me.
Thank you very much. I wanted to just make sure I understood the FDA side of this.
Okay.
I think what you're saying is one path to the FDA, which would make sense to me, would be that the FDA agrees to consider an application in advance of the expiration of exclusivity. exclusivity, a generic application, in advance of a year in advance of the expiration of exclusivity. And then when the exclusivity expires, then the approval happens and the 1498 is used. Is that fair? That's one possibility, one path here.
Oh, no. So I should clarify the timeline. So I was envisioning a world in which 1498 is invoked in the very near future,
Okay.
and we contract with a generic company who's willing and able to, enter into all of these sorts of situations, and then with a paragraph for filing, that generic company can apply to the FDA 1 year before the expiration of the 5-year new chemical entity exclusivity.
Fair enough. That clarifies that. No. I think that's but under that circumstance, just to be clear, it's an ANDA they're filing.
Yes.
And so it's a basically same standard as would be applied to any generic medicine. They're looking at bioequivalence in that review.
Yeah, so I view that slide as presenting sort of 3 separate options.
Right.
So one is normal. We're proceeding as if everything is normal from a generic perspective. Filing paragraph 4, getting approval at the end of the exclusivity period. And then there are other ways which are accommodations to the system, to the account for the unique nature of what we're doing, such that the commissioner might work with us to get the product on the market more quickly.
Right. I mean, from my perspective, I'd like the normal route, if possible.
Yes.
And that route would be essentially the medication starts to get reviewed a year before and then would be approved like any other generic, will eventually get approved.
Yes, that's right.
The only thing that's different about this application is that it's earlier because of this mechanism.
Well,
really.
There is the slight complicating factor of what does it mean to use 1498 and have the patent still be in existence. This is my uncertainty about.
I'm more thinking on the scientific side.
Yes, that's true.
It's the same review.
Same. Yeah.
That's sort of option A here.
Yes, option A.
The same scientific review.
Yeah.
The other options are for maybe you could do it a different way scientifically.
Yes.
But there is a path that is basically the same ANDA review.
Yes.
That you're talking about here. I just wanted to clarify that. Other questions for Rachel?
So it sounds like when you talk about the populations, that there are various things to consider that are different for each of these groups. So how in your opinion, how specific should we think about being? Should we recommend being, and kind of how increasingly complicated does it get as we add each new group?
Yeah, so I think it's tough because state Medicaid programs is the easiest case. I think that's clear. But I sort of think the big prize is the prison system. I think if we could do that, that would be fantastic. And there, my fear is that either we need to get the Department of Justice involved, and I'm not sure how specific we're supposed to be to this particular point in time, but I guess I'm just not sure that of all the people who would be on board with this particular action, I'm not certain that Attorney General Sessions would be.
I'm going to presume that people will be persuaded by the value of helping people in Louisiana.
I'm going to go with that too. That sounds great. So, it's one more person to persuade, and it's one more department whose resources need to be allocated. Mm-hmm. So I think it's always easier to persuade maybe fewer people. I shouldn't say always easier, but so if we could get at some number of those people using 340B or using 1115 waivers, I think that might be. We might present a couple of options.
But when you say using 340B, you're saying using 340B as a way to get to 1498, right?
Yes, as a way to get that population in under the for the government use.
Right. Okay.
Yeah.
You're not saying we have to rely on 340B pricing.
No.
Saying, okay.
No.
But just saying they
right.
fit into the
now, one population you didn't have up there was the uninsured.
Yes, I did.
Oh, you did?
Yeah.
Did I miss it?
You can see it. It's in the printout.
The one that I didn't see was state employees. Would they be in the first one?
So I did not have state employees on here. I didn't think that was one of the key populations. I'm happy to talk about it now, I guess. So I sort of thought about state employees as more akin to private employees because they're in the working population, and so they have a slightly different demographic profile. And then also the employee health plans, I'm sorry, I'm only familiar with the federal employee health program, but I assume the state ones have some sort of negotiating power to deal with these as well. And so I hadn't thought that that was one of the key public health concerns, but it may be.
No, I just wonder from a legal perspective, would that be the easiest one to?
No, I don't think it's easy to get.
It would be hard.
It would be hard. It would also be hard to get to just normal private insurance.
Well, I got that.
Yeah.
And you would put the state employees in the private insurance category in that regard.
I think they're more like that than they are like state Medicaid enrollees or state correctional facilities.
But Josh, to your point, the key issue with 340B is that it's supposed to serve the uninsured and the underinsured, and therefore, I think Rachel's point about 340B being critical here for meeting that need is valid.
Got it.
What about using constitutional law to try to get at the prison population? There's a unique constitutional obligation to provide care to prisoners in a way that there isn't. Could you use that?
Yeah, and so the Eighth Amendment is what underlies the 42 U.S.C. 1997. So absolutely, yeah, that's in support of that, and it's an extra argument that can be made, absolutely. But I think the statute and some of the precedent around it gives some more content that can be used. So absolutely.
And there are cases now that are testing that.
Yes, but I don't think they've gone to judgment, have they?
No, there's one in Massachusetts, and I don't know what happened to one in Pennsylvania yet.
I think even with the prison system, 340B could be invoked at least for the federal prisons. I'm not sure about the state prisons. But currently there are states that are already using 340B to provide medication access to prisoners.
And I would say that I would take any more information about 340B that anyone has. I feel like when I try to look for it, it's almost all rumors, and then I'll see X number of states or X number of facilities within states are using this, and they don't want to admit they're doing it because Congress really doesn't like that they're doing it. And so I think it's a little bit of a hot button topic. Rena, do you agree with that?
Yeah, I do, and I'm working with a number of states right now to try to clarify exactly when they can and cannot use 340B. There's been some, let's just say, inconsistent guidance from HRSA that the states are a little bit worried about. So the expansions that are going on, which are actually quite considerable, are very much under the radar.
Yeah.
For an intended purpose.
Right.
But I'm more than happy to talk offline about where you can find reliable information.
Okay.
Great. Other questions?
I have one more. Do you think it's possible, this is something we suggest in our paper and that I think I'm more of a fan of than my co-authors, do you think it's possible that there would be an argument that 1498 was passed well before we had the current drug regulatory structure that we have now, and for it to really work anymore in this field, there should be some sort of just general exception to the regulatory laws on this? Because you can't.
There's certainly an argument to be made, but the FDA has lost in court when they've tried to deny exclusivity periods or break exclusivity period, because the statute says shall grant exclusivity period, or shall not approve drug, or shall not accept for marketing. And now those are district court decisions, and I suspect they haven't been appealed for a reason, which is that the FDA just doesn't want them to be reviewed and to set greater precedent. But this is something I know that the FDA is worried about, especially in the context of things like gaming of the Orphan Drug Act. They don't want to be granting these 7-year market exclusivity periods, but courts have said they have to. So I think that should absolutely be part of the discussion, right? Yeah. But I'm not so sure that it would still anyone.
Right. In this case, though, the exclusivity runs out December 2018 for one of the medicines.
For one of them.
And so when's the patent run out for that medicine?
Oh, in the 2020s, much later.
Much later.
Yeah.
So, I mean...
There are several patents on it, and they run out at different times.
Right. So you might need all of the patents to run out before you could do a generic?
If I mean, otherwise, yeah.
So it could be quite a number of years.
Yes.
So, basically invoking 1498 in this case would potentially save many, many years. And during that period, you have hepatitis C replication and other things.
Right.
Aaron.
Yeah, so again, I think that's only though if you want a generic, and there's no inherent reason why we need an interchangeable generic in this case. You could use the 505(b)(2) pathway and you can get a product approved. I mean, the FDA, when there's a shortage, then the FDA needs to import a drug that's the same product but made by a different manufacturer overseas. It does so kind of under its emergency powers. So I mean, I think all of this, that whole kind of 5 years, 4 years, all that kind of dance is only true if we want a approvable, interchangeable ANDA, and we don't necessarily need that because we have a manufacturer or a purchaser that's going to be very strategic in the purchase and where it comes from and the price that they're going to buy it for.
Yeah, I would just add on to that one. Looking back at the tetracycline case, for example, back in 1960, that when these measures were made, on the one hand, there are already competitors producing these products, but they are not bioequivalent, right? Like the burden of proof at that moment on time was on showing proof of difference rather than showing proof of similarity. And since that time, we've elaborated this whole regulatory structure to document proof of similarity. And yet, as a result, you know, if we're getting ourselves into a circle here around the strictures of the ANDA, I think that Aaron's point here, let me know if I'm taking you in the wrong direction, Aaron, but that suggests that looking back at these questions of to what extent demanding proof of similarity actually gets us in trouble and is not necessarily in the best interests of resolving a public health situation. So this question of how that creates an additional legal challenge for us right now, because the concept of what an acceptable alternative drug has changed over time, and yet also, you know, doesn't get us out of the burden of actually trying to provide equivalence.
Right. So this is, of course, one of several paths we could take. Right. Yeah. Plan A might be normal scientific approval of an ANDA path. Second path might be 505(b)(2). Although I don't think 505(b)(2) gets you out of the 5-year exclusivity period entirely.
It does. But it's because it's not an ANDA. It's not an ANDA approval. It's an NDA approval.
Right. But if the NDA is infringing some of the patents from the
that's a patent infringement question, right?
Yes. And so there are still questions that I have about whether you could invoke a paragraph 4 in that context, and I don't know.
But paragraph 4 doesn't relate to 505(b)(2). And a patent is not an issue in this case because you're inherently invoking 1498. So
yeah,
I don't think it's getting you in trouble necessarily, but I just don't think it's necessary to contort yourself in this way when really all we're doing is we're just trying to find a way of just getting the product across the border.
Mm-hmm. And so, Aaron, let me follow up with a question. If you were doing the 505(b)(2), the nature of the application would still be bioequivalence, wouldn't it? I mean, you'd be demonstrating that, like, in other words, the FDA still wants to assure that this is a medicine that's going to work.
So, yeah, well, but bioequivalence, first of all, I think sort of, far be it for me to lecture you what bioequivalence means, but I think that bioequivalence means that that's only in the context of a generic, and a 505(b)(2) is an approval of a new chemical entity, but on the basis of less data because there is known similarities between your product and the other product. So if you can get a 505(b)(2) if you have a different formulation, a patch formulation of a pill or something like that, where we all know that this product, whatever, works to treat depression or whatever because of the years of experience with it, but here we have a slightly different formulation. It's not bioequivalent, it's just approval, but with less original data needed.
502.
What's that?
I think Basaglar was a 505(b)(2). Is that right, Aaron?
Basaglar, the new insulin product? Maybe.
Yeah, I guess I'm just saying that in the end, FDA is going to want enough data to feel like it's a safe and effective product. So that could be through showing a bioequivalence in whatever form you would want, and then relying on other data, or it would be it's different, but we still think it's going to work, and they'd have to show it. So the scientific barrier is probably simplest if it's a straightforward ANDA, I would think. Mm-hmm. So these other paths might exist, but it doesn't just create enforcement discretion kind of questions, it creates scientific questions to be sure that you have a path to understand it. what's going on. In this case, December 2018 may be the time everybody needs just to get ready to do the project. It may not be that much of a barrier.
Right.
But in other cases, I think what we're learning is that we want to stay open to these other ideas. And there may be different ways to determine that a medication is safe and effective than relying on bioequivalence alone in a typical ANDA pathway.
So I think it's very important to be clear that if we are going to highlight these specific populations that would be covered under 1498, then that also has implications for what damages would look like. In particular, the fact that we're going to invoke 1498 for the state Medicaid programs and also for the uninsured under 340 that would be potentially getting coverage or getting care under 340B, and that naturally implies that the Medicaid statutory plus supplemental rebate and or the 340B price would be one natural benchmark that the court may want to consider. From my perspective, that would have to be a ceiling price, but one that should clearly be considered in the deliberation.
Right. Although they're not able to afford that price, which is why they're not making it available. So.
Yeah, absolutely. I mean, if we're talking about Sovaldi, we're still talking about a per person price of approximately $24,000 per person under 340B discount. So that's still unaffordable for a state like Louisiana, but also for many other populations that would be covered under government programs.
Mm-hmm. So I have a naive question. So say this does apply in Louisiana. Mm-hmm. For one or two things. Does it then apply in Alabama? And does it apply for all the uninsured in America? When this would occur, how broad would it actually apply to?
So some of the determinations are context specific, but others are not. So in my view, the Medicaid case is really easy to make and is very, very easy to scale more generally. It's a little bit harder to scale the correctional facility one. A little bit more generally, you would have to have the Attorney General looking into the facts of the particular state, probably. But you could absolutely use some of the 340B tools, the Medicaid waiver tools. But that, as I've said, if you have a state that hasn't expanded Medicaid, that calculus looks very different for that particular state.
Would each state have to make their own application for this? Or if Rebekah Gee does it essentially mean that all 50 states get advantage of this?
At the federal level, yes, but whether a particular state population can then claim use for the United States might be subject to some fact-specific questions. I think that it would be very easy to meet that standard in almost every state for most of these populations.
But I want to narrow the question a little bit more. Okay, so because this goes back to the discussion that I was talking about, which we're going to set some principles for use that might be beyond what is required by the law. So if we set a principle, for example, that the state has to, have a path to make the medication available at the price, and let's just, would it be? Do you see? Is there a legal barrier? And this might also be a question for Hannah. If you were to say, well, in the first instance, the federal government's going to invoke this for Louisiana because it's made this commitment. In other words, does the use of 1498 have to be all or none? Or could it be for a discrete population? Could it be for the Medicaid enrollees in Louisiana and the state prison population in Louisiana? And then, maybe there would be the legal basis again to go broader, but the actual use, is there a reason to think that couldn't it be like our government use in this case is this particular state because they are meeting all the criteria that we set out?
So I think they could do that, and Hannah, you might disagree with me. The one wrinkle I would see immediately is that we've already seen a number of lawsuits on the state level against Medicaid programs that are not making these drugs available. And so the minute you have one state able to access them on a much more affordable basis because of something the federal government has done, I would expect lawsuits in many, many other states demanding that their state governments make the same accommodation. Right. Do you agree?
Yeah, I agree with you. And I mean, I think the easier example of when you could just do it for a particular population would be 1498 would be extremely easy to use for the VA.
Yeah.
So right away you could do VA or Indian Health Services.
If Louisiana did it, would it automatically apply to the VA?
No.
So they would still have to make an application.
Well, it would be up to what HHS asked
Yeah.
for. So
Right.
in this case, what we're talking about is
Right.
Dr. Gee is asking us, should Louisiana ask for it for Louisiana?
Yeah.
Then the question goes to HHS, okay, you've got a request in theory from Louisiana.
Yes.
Are you going to just ask for Louisiana
Or
or are you going to ask for more?
Yeah.
What you're saying is there's no legal barrier preventing them from just asking for Louisiana, but they might look at it at HHS and say, well, the
minute
logic
we do
applies
that, right.
equally well here, or we know the IHS could make it available to everyone.
Yes.
So it would become an issue for how broad HHS wants to use it. But there's nothing that would prevent Dr. Gee for asking for it just for Louisiana or for it to be granted on that basis.
Yeah.
And I think you're right to point out that that would be litigated. Once you give something to someone, then other people expect that they build a right in it, or they build sort of an entitlement to it based off of what you're. But that would be down the road.
Yeah, I guess when you
Yeah.
say that would be litigated, what you're saying is that might
Be a question.
ask other. I think what you're saying is, just to be clear,
Yeah.
other people might say, we think we'd like that deal also.
Yes.
Yes.
And not that people would say it's illegal for the federal government to do it just one state necessarily.
They might.
That's how they would pose their legal argument. So they would basically say we'd like that as well, but how they would litigate in front of the court.
Right, who knows what argument they would make.
Right, is you gave it to them, so you have to give it to us.
Yes.
Right. If the but just
Yeah.
as a flanked here by the two lawyers here, but from your perspective, you would see that HHS could ask on behalf of Louisiana. It might set up some questions later, but there's nothing in the way the law is written that requires it to be national in scope.
Right, and so the HHS ask on behalf of Louisiana is going to ask about the prison system. It's going to ask about some of these other populations, and that's not necessarily going to be the case in other states. So I think this, it could be cabined to Louisiana, and it's a fact-specific inquiry, but I think the HHS is going to look at this and say, we know that
Right.
these other suits are going to be coming the minute we say yes.
Mm-hmm.
Right. And those may not necessarily be bad for public health if it's,
Right.
if it's the case
Right.
that there are other people who need hepatitis C treatment. But
Right.
I think there's a potential intersection here between the legal and the policy if the reason there's something being done in Louisiana is a policy reason. That, we're saying that, the request is coming in a certain focused way for a particular policy reason.
Yeah.
That
Yeah.
would have to carry through for other states for it to be consistent. Otherwise, it would just be opened up.
Yeah, and I bet there are a number of ways in which HHS and CMS could say something like, well, we want to be sure that the state has taken all reasonable steps to solve this problem on their own. If the state has not expanded Medicaid, perhaps they're not eligible for this particular benefit. Or if the state has a much lower federal match under Medicaid, maybe they're not eligible for it as well. These are just possible
Right.
policy concerns that I could see the agency expressing.
Okay. Fortunately, we're not being asked to write a letter to HHS yet.
Yeah.
Right? Just so we
Fortunately.
So we'll all right. Any final questions for Rachel Sachs? All right, thank you so much. This is such an interesting conversation. We're going to take a 10-minute break and then be back for the last two sections. Thank you.
Thank you.
Thank you. Great job.
Aaron, you still there?
What?
Aaron?
Yeah.
All right, we'll be back.
Okay.
I'll wave at you when we're back.
Okay.
All right, we're back from our break here at the Johns Hopkins Bloomberg School of Public Health. Josh Sharfstein. We're having a meeting about Section 1498 and hepatitis C, as well as voluntary licensing. I want to just take this moment and thank two students, Madeline Jackson and Joy Lee, who helped put this meeting together, and also thank Owen and the team from the school that's doing a great job figuring out how to get Adobe Connect to work for multiple partners in real time. So thank you guys, and thanks to Madeline and Joy. So we're now up to some economic considerations, and Professor Conte will turn it over to you.
Thank you very much for the opportunity to come and speak to the conference. I'm sorry I could not be there in person. This has been a fascinating day. Do I have control over my slides?
We think so. You try the arrows on your screen.
Okay, great. Thank you. Okay, so I want to pick up our previous conversation about what the statute actually says to really focus our attention on what would damages or payment be to the patent holder under this circumstance. So the statute is very clear. Whenever an intervention described in and covered by a patent of the U.S. is used or manufactured by or for the U.S. without a license of the owner thereof or a lawful right to use or manufacture the same, the owner's remedy shall be by action against the U.S. Court of Federal Claims for the recovery of his reasonable and entire compensation for such use and manufacture. So from my economic perspective, the statute implies two takeaways. The first, that the government may negotiate a license in the shadow of its 1498 power, or the government can simply make or purchase the invention, as we've been discussing here today. And secondly, if the manufacturer is dissatisfied with the government action, they can sue for damages in federal court. There are several strategic incentives under this statute, given the economic considerations that are at issue. The first, and this is critical, is that the statute does not afford the patent holder injunctive relief against the federal's use or manufacture of the invention. In other words, the patent holder cannot hold up or walk away from the government invoking 1498. This is very similar in intent to eminent domain. And essentially what this means is that the patent holder can only use the courts to recover increased compensation based on whatever the government has already decided to offer the patent holder. It cannot use the courts to simply stop the federal government from invoking 1498 and manufacturing or licensing this product under a reduced rate. Secondly, from the government's perspective, the largest downside risk of low patent holder compensation is reduced private incentives for future investments. The importance of this risk is dependent upon the structure of the industry. Clearly, in a very robust, very competitive pharmaceutical market as we have now, where this would only be invoked for very selected cases, then the downside risk is actually quite small. And in some sense, one could even think about the risk premium that these manufacturers are already raising funds on the private market, baking in this risk if it is salient to them. Secondly, political economy can clearly make this risk more or less salient. Earlier in our discussion, we were talking about the convenience of forgetting the use of this clause. My view is that part of that has to do with this clause being more or less relevant given certain political circumstances, which include the nature of the innovations that this clause may be important to, but also the nature of the political discussion about affordability in prices and the importance of public health concerns more generally. So what is reasonable compensation under 1498? As has already been alluded to very nicely, case law is clearly limited. Previous pharmaceuticals cases have settled quite quickly. Clearly, there is some strategic reason why these cases have settled, in part to reduce the opportunity for setting case law. We know that there are at least 2 examples of the Department of Defense using 1498 to purchase specific drugs. There, the range of remedy is in the order of 2% for nitrofurantoin in 1972 and 72% off list price for tetracycline hydrochloride. Previous presenters, Hannah and others, have discussed the theoretical basis for compensation, which include reasonable royalties, percentage of government cost savings or lost profits. And for all the reasons that have already been discussed, my view is that reasonable royalty is the most tractable from a perspective of calculating damages. But even in this most tractable approach, there are considerations that should be discussed. Really, my remaining comments focus on how one would actually calculate reasonable royalties given a very specific case, but I'm more than happy to talk a little bit more about the kind of strategic issues in incentives here for the government, but also for innovators moving forward. Okay, so there are 3 potential yardsticks or benchmarks for applying the royalty standard to damage calculations. Method 1 would be to use existing royalty payments that either the manufacturer itself or other industry standards or equivalents have used for equivalent products. The second would be to use marginal cost of production as some sort of benchmark upon which to produce reasonable rates of return for the industry. And then method 3 would be the use of development costs plus some sort of reasonable rate of return. Both of these latter cases are really using the Louisiana case as a precedent for establishing benchmark royalties. Data sources for damage calculations would be the following. First and most importantly, and not on this list, is discovery. Clearly, many of these, the ingredients of these damages would have to come from the manufacturer itself, or at least would be preferred to come from the manufacturer itself. But again, we can rely on historical benchmarks and academic literature to at least get a yardstick calculation going. For method 1, we would use existing royalty payments that the manufacturer has used, again, in discovery, but also could use existing royalty payments from the historical perspective or from academic literature. For method 2 and method 3 to go, manufacturer estimates academic literature would have to be invoked, but again, discovery could be relevant here. Okay. So I'm now going to apply these 3 standards or these 3 methods to the specific case of treating hepatitis C with the new drugs. As you all know, there are 6 branded therapies that are indicated for this condition. There are 3 unique manufacturers that make these drugs, and the list price, or the average wholesale price of these drugs were launched at, is listed here, somewhere on the order of $54,000 per person for a completed course of treatment, all the way to $95,000 per course of treatment, per person treatment. So in terms of the first royalty calculation, it's important for you to understand where my ranges of royalty estimates would come from. So again, these are royalty estimates that are drawn from the existing literature on what royalty payments on top of average wholesale price would be. There are, in Amy and Hannah's paper, there are a range of estimates that are listed through previously published studies. On the low end, the 2% of AWP is also the historical precedent number that I alluded to in the Department of Defense case of nitroneurotoxin. But there are examples of royalty payments going all the way upwards of 20% AWP. One other thing that's very important here is that the amount of royalty payment is really dependent on the assuredness of the product being a go and actually launching into the U.S. market. Earlier or smaller royalty payments bake in the uncertainty of not getting all the way through FDA approval, whereas the larger royalty payment estimates here of 10 to 18% have been paid in cases where the drug has already gone through phase 3 testing and is ready for launch. So here you can see that based upon these assumptions, these list prices of somewhere between $55,000 to $95,000 per person treated would be reduced to somewhere between $1,000 to $17,000 per person treated. In terms of royalty calculation method number 2, here I need 2 estimates to make this a go. The first is an estimate of the marginal cost of production, and the second is what is a reasonable rate of return. Now, marginal cost of production is something that, again, each manufacturer should know uniquely for this specific product, but also across their portfolio. There's entirely good reasons why some manufacturers may be better than others in the marginal cost of their production due to gains in scale and scope. But so again, discovery documents or having the manufacturer provide this information to the court or to the government in negotiations would be helpful. But we can always use published estimates. Now, in the case of the hepatitis C drugs, we have estimates of what the marginal cost of production is for Sovaldi. They're public. They amount to approximately $130,000 to $150,000 per pill. If you gross that up, you get to a 1% average wholesale price as an upper bound on production costs for the entire course of treatment. That's listed here on the left-hand column, but even being generous, we can go further upwards of the marginal cost of production to 10% of average wholesale price and get to estimates that make some sense. Secondly, in terms of reasonable rate of return, again, I would argue there's probably some economic rationale on either sides for using within manufacturer estimated rates of return versus between or average rates of return that include failures. In this calculation, it can go either way. I'm more than happy to debate that with you all. But essentially, what we know of for published rates of return are somewhere on the order of 10 to 20% in the pharmaceutical industry when we bake in or account for failures. 30% is an upper bound, but it's one that is possible for certain types of manufacturers that we know of from public documents. So here, if we combine the marginal cost of production with a reasonable rate of return, given the list prices that we see for these drugs, we come up with a per person course of treatment estimate of somewhere between $600 and $1,200 per person per treated for the course of treatment. And then finally, there's method number 3 for calculating royalties, which again combines development costs with reasonable rates of return. Here, again, it'd be really nice to have the manufacturer tell us what their development costs are. As has already been alluded to by the panel, one potential benchmark would be royalty payments or licensing that it's already potentially occurred that baked in some of the estimates of research and development that was actually funded by the manufacturer. But again, we have development cost estimates that again bake in this risk of failure from the public, sorry about that, from the public academic literature on the order of somewhere between 300 and 1.2 billion for a successful FDA-approved molecule. If we apply that standard to the prevalence worldwide of this condition, which amounts to approximately $170 to $200 million per person across the U.S. or sorry, across worldwide, according to the World Health Organization, and we divide development costs over the lifespan of this product to the prevalence estimate, we would get $1.1 to $6 per person. We would gross that up by the reasonable rate of return of 10 to 30% to get a per person royalty treated of $1.6 to $7.8 per person treated over, again, the course of the treatment, not just per pill. So again, these kind of individual estimates that are somewhere on the order of $500 to $20,000 per person treated need to be kind of grossed up to get a sense of what a state or government royalty payment would be to treat a target population. Here, I've used the potential population of Louisiana that would be treated who are covered under state or federal payments or insurers with hepatitis C that would be covered under the 1498 clause to kind of get a sense of how much this would cost overall to the state. And I get an order of an estimate range of somewhere between $48,000 to $510 million, depending on which method I use. I'm going to stop there and say there are a handful of other considerations that are incredibly important, most notably to what extent would these federal payment programs, either Medicaid or 340B price, act as an additional benchmark or guardrail on these damage estimates. I'm happy to talk a little bit more about that. I also think that there are some economic considerations about would we want to invoke 1498 across all manufacturers of a given therapeutic class that we've targeted, or only one. I do think that there are some economic issues related to which would be potentially get us a better deal that I think are important to consider. Thank you.
Thank you very much, Professor Conte. Would you mind commenting on that last question about one versus more than one, and just explain a little more what you're thinking there?
Sure. So, so in the case of hepatitis C, there are 3 manufacturers, there are 6 drugs. There are key considerations in which drug would you choose or which manufacturer would you choose. From my perspective, again, this is about improving public health. So the first consideration would be which is the drug that is going to most effectively and safely treat the underlying condition that we're attempting to eradicate or treat. Secondly, would be some secondary considerations of innovation incentives, which I think include, would you want the first generation drug or the second generation drug in a drug class that is crowded by both to be invoked to be the target of 1498. From my perspective, if the first generation drug was both safe and efficacious for the target population, that would be slightly preferred here because we want to preserve incentives for follow-on innovation for the government, but also the public health needs more generally. And then lastly, there's the issue of, well, is 1498, shouldn't 1498 be invoked on one manufacturer within the DAA class, or should it be invoked in all? And then essentially we would have a licensing bake-off, if you will, between manufacturers for bidding, for price bidding purposes. And my preliminary back-of-the-hand calculation suggests the government would potentially be better off with the latter scenario, that instead of invoking 1498 on one manufacturer, could potentially get a better deal if they entered into some sort of licensing bake-off between manufacturers and could potentially get exposure to the lowest price, but also an intermediate price without potentially the downside risks of going to court.
Dr. Kesselheim, did you have a question?
I did, but I got distracted by the idea of a bake-off after eating muffins.
Sorry, all of you who are in Passover.
But if I can remember what my question was. Oh yeah, so so why did you use AWP as your number as opposed to the price that the drug company might have actually spent or received from the product? And then my second question is, using a rate of return that the industry-funded economists like Grabowski and Damasi have set, is maybe what is the, like, is that the right number to be using, or should we be using a number that's more relevant to this particular case when Gilead made its investment after the phase 2 studies were already done and positive, and the risk of failure in this case was much smaller than the risk of failure on average?
Sure, great questions. The first is that AWP is simply list price, and for the royalty payments that I know of in historical benchmarks that have invoked 1498, they've used list. And so that's just a simple way of starting this conversation. I agree with you. One could use a different benchmark. One could use WAC. One could also use net reimbursement price now after launch. One could also use a list price after launch as a potential benchmark. If we were doing this for real for a damage calculation, we would likely want to do all three of those. On rate of return, again, this is just a starting point for calculation. My view is that it would potentially be preferable to use the manufacturer's own estimates of what their R&D costs are. It's a little complicated because obviously some of these drugs have used considerable investments by the public sector as well. Hard to kind of maybe, depending on the record, it may be more or less difficult to apportion public versus private investments. But again, I think that there's good precedent for kind of thinking through. We would just want actually to think about the private investment, not the public one. And then, or we wouldn't want to give them credit for the public investment, in other words. But again, it's just a way of kind of getting practical estimates out there. We may also want to consider private rates of return that wouldn't bake in failures. We know that the failure rate in the Damasi and Gromowski numbers is a little bit woofy, to use a technical term. Failures can occur both because of true scientific dead ends related to safety or efficacy concerns, but also because of strategic business decisions. And we wouldn't want to give them credit for strategic business decisions in the same way as we think of true scientific failures. So could be work to be done on that. What I would argue, again, just from a first back of the envelope damage calculation perspective, we would want to go with the lower bound numbers, not the 30%.
Great. I'm sure there are a lot of other questions. I have a bunch, but anyone want to jump in? Jeremy?
Yeah. So I have two questions. I think the Gilead is very interesting because we have a lot of the information about from the Senate finance documents. We know that Pharmasset spent $86 million developing the drug before Gilead bought them, and they spent approximately $300 million afterwards on post-marketing trials. So, and we know that Gilead spent $11 billion buying Pharmasset. So if Gilead wanted to get a return on their investment, would you look at their investment, the $400 million in direct cash outlaid for their research, or the $11 billion that they spent on Pharmasset? And kind of related, another question is, would you compensate for the value of the patent, or would you compensate for the use of the patent? So would you pay for the 30,000 or 34,000 treated with Hep C in Louisiana, or would you compensate for what the patent is worth to Gilead, regardless of how you use it?
So the law is very clear that our precedent is very clear that we shouldn't be compensating based on what lost profit is. So on the last point, I think what we're really talking about is R&D costs alone for or the pleasure of using the product for the specific patient population in Louisiana in this case, but in another state or more general population more generally. So that's why we need a royalty rate, a royalty payment that would be per person and that wouldn't bake in all the lost profits. So that's the first issue. The second is on Gilead's R&D spending. Again, if we use the just their own documents, we would get to an approximate 11 billion plus 400, so 1,200 billion invested. for R&D, that's again gets us onto that very lower end of my scale, but it's not. So again, my numbers could be inflated. Are they inflated by a factor of 100? I don't think so, but they potentially could be inflated by a factor of 10.
So,
Well, I mean, the 11 billion that Gilead paid to buy out Pharmacet, it's almost it's fictitious in a way, because they determined that value based on how they would want to price a much higher price. And out of that 11 billion, little of it went to actually researching the drug. It was just a reward of current shareholders.
So,
I mean, absolutely. Yeah, no, absolutely. Which is why profit is not should not be the benchmark here.
Okay.
But again, we have to kind of start from something.
Yeah.
And my view is that discovery documents or specific attestments by the specific manufacturer of what they paid or didn't pay in for R&D is an important aspect of this calculation, but it can't be the only figure that we would use to estimate development costs. And again, these other academically peer-reviewed estimates, with their warts and all, would have to be part of this conversation.
So I have a question which is like maybe a combination for you, Rena, as well as for the attorneys here. One of which is, does it matter economically or legally that the company may have already made quite a lot back against its $11 billion? In other words, it's not just they're out $11 billion, but by some estimates they're up another $20 billion or something like that. You know, would that factor in? And my second question is it appropriate if we're thinking about, given that we've just went through which populations are eligible for 1498, to think about what the reasonable cost would be by population, because it might be different for different populations. If you could imagine the analysis being different, is it appropriate to think that Medicaid might be one number, but uninsured or prison might be another number? So anyway, those are two questions that come to mind. I don't know, Rena, do you have thoughts about that?
Yeah. So I have some thoughts, and then I'll cede to the lawyers when I get in trouble, which is the following. Again, I think lost profits, whether they're as a benchmark, is just clearly problematic from the court perspective. If we just thought about making up our R&D investment, then royalty calculation method number 3 under Lusona as the precedent, works here. And that gives you a per person for full treatment costs of under $10 per person, which seems pretty close to zero in terms of if we think that the company has already clearly made their full investment of the sale of the $2.
Other thoughts on that or other questions?
Yeah, I kind of find this tough, and I had written down what to do with the fact that lost profits are sort of zero, because this is not a population they would have been selling to otherwise, and I totally understand why that is problematic. The only other thing I wanted to add is that companies will do basically anything they can to not disclose information about their own R&D costs. And so with Gilead, it's interesting because a lot of that is now public because of the Senate documents, but that may not be true for the other companies we're dealing with. And even with the Senate documents, there's a lot they leave out. So that's a powerful tool encouraging settlement, the fact that they don't want anyone to know exactly what they're spending. And so I think it's just something to consider as we go forward with this.
I
I
agree.
don't want to keep asking questions. Others? Thoughts, questions?
I guess one question I had also probably for Rena plus Rachel and Hannah maybe is when thinking about, which of these companies to target or however the right phrase is, how does that interact with the market exclusivity and the fact that some are further away, and how should we think about that? Multiple of them, one of them? Yeah.
I can't answer. So I think I really like Rena's framework of we should stick with sort of the science first. If there's a clear scientific answer, that's best. And then I would love to know more some of the economic considerations around having multiple companies sort of bid against each other. That could be very beneficial. But from a legal perspective, there's two things I think about. So one is exactly as you said, Gilead's exclusivity periods expire earlier than AbbVie's or Merck's. So depending on when we get this together, that may matter, that may not matter as much. The other thing is that Gilead did lose a patent infringement lawsuit to Merck.
Oh, right, yeah.
And so what I wonder, and to AbbVie, there was a settlement. What I wonder is if we moved forward against Gilead, would the product then be infringing Merck's patent and subject to a lawsuit from them? And I don't know the answer to that. I don't know exactly how that would work, but it's a complicating factor.
Yeah.
You'd have to use it against both, I think.
Mm-hmm.
Yeah.
I have another question. Is there, do you have any thoughts on using a value-based pricing mechanism to compensate? I know there's a lot of issues. What's a reasonable willingness to pay threshold, all of the other issues. But if ICER said Sovaldi is cost effective at $15,000 per case or whatever, is that a route to go down?
I think what you're referring to is using a quality-based estimate with a per person life year saved dollar amount to convert. My view is that that's fine when we're talking about the general population as a potential benchmark for pricing, but when states or commercial insurers have thought about using value-based pricing in this setting, we're talking about prices that are much higher than the royalty estimates that I've come up with. They're on the order of the 340B or even higher price. So again, I'm not sure they're actually relevant here.
The challenge in here in the pricing is you're looking for something reasonable. You're trying to figure out reasonable at a time that the market isn't providing it, or people aren't coming together in the market because it's unaffordable at the current level. So you're saying, well, at what point does it become reasonable?
Mm-hmm.
And this is a very helpful presentation because you're showing different ways to think about what could be considered reasonable. But if we're going to have a recommendation or we're going to think about this, we need to, if not pick one, find one that seems more reasonable than the others as a way of defining reasonable. Professor Kapczynski, I hope your class went well.
I think it went okay.
Okay, so you're like the reinforcements here at the end. If you have, we've just been talking about the different ways to figure out what a reasonable payment would be to the patent holder. Do you have a preference in?
Yeah, so I guess because I'm coming in at the tail end, I'll kind of describe what I think might be a little bit of difference between how I and the group I wrote with has proposed this and what Rena is talking about, which is that we propose not just covering the cost of R&D, but trying to figure out how to adjust that for risk, with not necessarily the thought that the case law requires that. I think it is susceptible to many interpretations, including that, you really, the courts don't always get very sophisticated about, sort of how do you ensure that this is a fair deal for companies. So I think it would be, possible that the courts would look at it sort of in the way that I see on the sort of slide before me. But I think it's also possible that you want to think about the fact that from an ex-ante perspective, the risk is going to be of consequence to the company, and so returns are going to have to be higher to ensure compensation for risk. Now, in part because what we're typically doing is talking about just one payer in a worldwide setting, and now in this context of a relatively small payer, the costs of error are not huge. Costs of error really become like, well, if we do this for 50% of the entire market, and then we get the payments wrong, then that's an issue. I guess on the value point, I guess the working on this issue has made me convinced that we shouldn't pay for not value. And that's where a lot of the value conversation came from. Like, it would be bad to be paying for drugs that were not valuable or less valuable than the existing interventions. But paying for value without regard to something like R&D costs strikes me as probably not the best way to proceed in thinking about what the company is entitled to. And that is really because of the budgetary constraints that we see before us when you have so many important competing priorities. So that if you didn't need this amount of money to get this drug, then the logical way to try to proceed about compensating a company is, or what did they need to get into this business? And the full social value of something, or value as it might be calculated, against the cost of liver cancer or something like that, is not necessarily going to be a logical way to kind of proceed, or the way that a company would proceed, thinking about value in that way. So I've tended to see, and I think the courts see through the lens of kind of how damages are worked out in patent cases. The question is really about sort of what's a fair, what's a fair return on investment, or sort of a royalty rate that is out there in the marketplace. If you could find one of those, it can be pretty far from the sort of value to when measured against, say, the cost of other interventions like liver cancer or liver transplant.
Yeah, so I agree with you. I think that my prior on this is that the marginal cost of production, which is close to zero here, is not the right number, or at least it's a very lower bound, and that the courts are going to be worried about the incentives for innovation and setting precedent that really could change the calculus for investments in R&D moving forward. Now, I personally think the capital markets can handle this type of risk if it's a known risk, and they would just kind of price it in. But nevertheless, setting a precedent of a very, very low payment has some knock-on effects that could be significant and also could be unintended. Lastly, I think. So really what we're talking about is kind of the upper bound of what, or the mid-range royalty 1 or royalty 2 payment method as being possible estimates here, or at least a starting place for estimates. And I also think that, particularly in this class of drugs, it's possible that there could be some horse trading between the price of the drug and the use of company infrastructure for actually defraying some of the costs of actually meeting the public health goal. What I mean by that here is that in the treatment of hepatitis C, this is true actually in HIV as well, some of the other public health diseases or diseases that are communicable, the companies already have invested in significant infrastructure for screening and also for getting screen positives into treatment. And from the government's perspective, you may want to pay a higher price or pay a lower price depending on whether you also get access to that infrastructure, because that infrastructure is costly. It's something the government would have to pay for if they just got the drug itself, but may be something that the company may put on the table in order to kind of preserve these incentives for innovation and return from their shareholders as well. So I think these are key considerations that the court would potentially want to consider, or at least explore.
Can I just add very briefly to that? Another thing to possibly put on the table is companies waiving legal rights for other things, which would include exclusivity periods. If we were having a really tough time with that, that's something else that could be part of the discussion. And so I think there's a lot of things potentially on the table. So that's a really helpful comment. Thank you.
Yeah, no, I agree. I agree.
That's all assuming there's an agreed upon arrangement as opposed to something that's worked out through the courts. Let me just ask one very specific question just to see, would anybody object to the idea of thinking about pricing based on the population, so that, you know, if Louisiana is going to pay for X number of people in Medicaid and X number of people in the, you know, prison system and X number of uninsured, that the compensation to the patent holder might be based on the class? As opposed to, or do you think it needs to be uniform?
When you say uniform.
Yeah, I'm not sure I understand.
In other words, let's say we're going to say, I'll just say right now, let's say Louisiana's paying $20,000 a person for 1,000 people in the Medicaid program. And I don't know the actual numbers, but then they're not paying for another 10,000 people. They're paying nothing. And so then in the prison system, maybe nobody's getting treated, and the uninsured, a very small number, or zero, are getting treated. So would you say, because there's some money, for example, if the basic analysis is this is a fair deal for the company, you know, if you were to say, well, looking at Medicaid, we already know this is the amount of money that's going, so the price for a Medicaid patient maybe on average should be about this amount. But it's a different calculus for the prisons, which have no ability right now to pay. Again, I'm not saying that's the case. I'm just using it as an example. But basically, that the way to think about it is, if you're using it for populations A, B, and C, they may have different considerations with respect to what's reasonable to compensate the company. So I'm just putting that out there. Would anybody object to that way of doing it? I can see the logic for it. I just don't know whether that, you know, would make anybody stressed out.
So it does not make me stressed out, but there is an argument that a lot of people, I think, would be stressed out. So in the U.S., I think we try to hide the fact that we pay more for drugs for some people and less for drugs for other people. And so if you made that really public and said, you know, this drug costs less when it's being used for one population. I mean, there are some economic concerns about arbitrage and things like that. Putting all those aside, there may be an optics problem to work through.
I mean, you could just average it over everyone and then just give it a single thing.
I'm okay with that.
Any?
The only other thing I worry about is that the pharmaceutical companies treat the price like a balloon, and because they're being squeezed on one area, they raise list prices for someone else that in the private market, and they say, too bad, now the private market is going to bear the costs we've lost from the government using 1498. And I don't know if they could really do that, because really the private market can't bear much more than they've already maxed out their price.
But I don't think I'm still kind of jumping in. If you assume they're losing money, I don't assume they're losing money. I'm assuming we're actually, they're going to wind up net getting more money.
Right.
So there's nothing to cost shift over, really.
Yeah, I think that's right. I agree with that, but the story they'll tell is that they are, and I don't know.
In part, I'm suggesting differential pricing in part to address that issue by showing that for each population they're getting, you know, basically what would be reasonable for that population.
So my prior is to keep this simple, to set a price that makes some sense based on calculations that are transparent and apply to all. And if we're going to discuss differential pricing on the back end, what we're really talking about is support to getting people screened and treated. Because clearly some of this population, most notably the prison population, but also the population that's co-occurring with HIV and hepatitis C, that's just a difficult population to treat for a lot of different reasons. And so I would rather, I'd rather have help on the back end in getting those people actually into treatment than complicate pricing or save some money on the front end in different types of pricing for different types of people who are more or less vulnerable.
I'll just add to that. I mean, I think, Josh, the approach you're suggesting is how I might describe to the state. I would think that maybe the upper end of their liability would be in the sense that, like, you were never going to pay more than this. And particularly given that under the royalty calculations, the way that courts have done them, they've said, you can't have lost profits. It's too speculative. The sort of thought that, your liability would be above this would seems a stretch, right? Even given uncertainty about how the courts might approach this. And so that would be the upper end. But that the way to proceed would be, and where you'd be sort of on the highest ground, I think, kind of conceptually, politically speaking, would be to say, we figured we're going to try our best to figure out what a fair compensation is for you, given the real critical policy question, which is that you did do some work to innovate, and we want to make sure that you're fairly compensated for that. And then the complicating thing, really, in my mind, has to do with sort of how to calculate, say, Louisiana's share as against the rest of the world, and also the fact that Louisiana's already paid a lot. So they might well have already covered everything. Just in the couple of years they've already been paying for these drugs, you would think their fair share might be. And so those to me are the kind of complicating factors of a proceeding in the way I was describing, and that I think has the kind of high ground both conceptually and politically. But yeah, that's helpful.
That's good. No, that's helpful. Look, if I cannot persuade this crowd, there's no chance for it. So that's good.
So I would add to Amy's comment that, Amy, I think you missed this, that in some sense, given the patient population that we're talking about, the Medicaid statutory plus supplemental rebate that the state is already paying, and or the 340B price is in some sense the natural ceiling price here.
I mean, I think what I was suggesting is it's the natural ceiling, even thinking about an expanded population outside of Medicaid, in part because the state's already, like, this is what the state's committed to. It's not going up. I mean, you have some complicated questions about would it have paid that next year and the year after and the year after and the year after, and, like, then it gets a little more complicated, but I think we agree on that.
I agree.
Right. All right, so I think we're headed home here. We're going to turn to Aaron Kesselheim for some wrap-up comments, and then we'll have a final few minutes of discussion, and then we'll be done. Aaron?
Yeah, no, thanks. I appreciate a few minutes to chat, although, again, I don't want to take up too much time because I think that from my point of view, the day's been most interesting when everybody's kind of had a chance to hash out some ideas. But I think, we heard from Rebekah that Louisiana is interested in using this pathway, and over the last 4 hours, I think that the general theme has been one of, well, how do we make this work, and not like, why can't we make this, why is this a bad idea, and how is this going to be problematic and dangerous and harmful, and I think that really says a lot about the possibilities. So I mean, I think that the comments from Hannah on the history were great and shows that this has been done before, and the world didn't end and the markets didn't crash and pharmaceuticals were still produced, and I think that I like Josh's framing comments about what makes this particular issue a special issue, a special case about in terms of trying to treat hepatitis C and eradicate hepatitis C from a disease that might otherwise be silently transmitted and yet still cause a lot of morbidity and mortality. especially among lower income patients. So, I mean, I think that the stars are in a pretty good lineup for this particular product. It's incredibly effective. It's a infectious, transmittable public health crisis that we can eradicate. It's a product that was developed in large part due to public investment in the discovery and elucidation of what the mechanism of action of hepatitis C is and the treatment for it, and for which the pharmaceutical manufacturer is charging a price that is unsustainable, and it's unsustainable by as evidenced by the fact that that a lot of these public health agencies that would otherwise be able to offer this product to their patients are just not able to do so. So I think that if any if there's any drug right now that is a candidate for it, it's this one, and I think that also bears that's a good reason as to why we should consider moving forward with this. And as to Rachel's points, I think that there are a lot of ways that an administration, an executive administration, if they were so inclined, would be able to facilitate this. But unfortunately, I think we're going to have to face the reality that that's not going to be the situation, and that the state might have to move forward in trying to procure this product on its own, and that's where I think Lena's comments are useful in helping establish the bounds in terms of a budget for what the state might need to set aside for the approaching lawsuits and PR battle. And I'm sure that they're going to have to face. So I mean, I think for me, the key questions moving forward is not whether we should do this, but what the next steps are, and who it is that needs to be convinced, and how they would then go about moving forward, and then try to make sure that we can deal with some of the issues about the larger policy issues, and what are the right circumstances in the future for invoking this sort of power in the background, but in the short term, try to figure out how to get this really important product to a bunch of patients who really need it in a circumstance where we have the authority to do it. So I guess with that, I just want to try to open it up for the last session, which I guess is intended to be more of like a practical brainstorming around where do we go next.
Great, thank you. I appreciate the kind of taking a few steps back and looking at the big picture. What we didn't hear was anyone saying, no, can't be done this way, despite 4 hours of discussion on every little detail that we could think of. And I think what Dr. Gee is interested in is some thoughts we have on how potentially this could be put forward. It seems to me that in the various areas we may have more or less details. There's obviously a really good historical discussion and track record to talk about. I think that there are some basic public health principles that we could put forward as examples, but with the idea that you don't necessarily have to wait to have the perfect set of principles to realize that this one is probably going to fit it. I think that's a key point that Aaron's just making. And that there are certain legal questions that might come up that there are answers to, and particularly for the core targeted populations that she's interested in making sure have access to treatment, and that there would be a very strong case to be made that the eventual payment to patent holder would be far less than what the prices are available at to the state now. So I mean, that to me, that's basically the justification. And it is certainly possible that in the process of thinking that through, that might allow for some voluntary discussions to be had. It may be, but let me pause there, and then I'll also pose one question, which is, given the National Academy of Medicine recommendation for a voluntary process, how would that best interact with the 1498? I mean, I don't think they were saying exclusively voluntary. I think that was their preference. I think we might all, that if everybody came together voluntarily, that would be a good solution. How do these two things work in tandem? So I'll put that out as well as my overall summary as well to see if any general reactions.
I have one question I'd like to come back to, and it's not a no thing. It's just trying to think about the difficulties of implementing this in the 21st century, right? And this comes to imagining like this distinction of there being, in the case of tetracycline, already an Italian firm that's making tetracycline that doesn't, is in a country that doesn't have product patents, right? Versus a world in which we don't have someone ready to go with the product in hand right now, right? I mean, I could be wrong on this, right?
No, in India, Mylan is manufacturing it.
But so Mylan is manufacturing it, but it's not ready to go in the standards of U.S. regulatory. So I'm just saying, it's the process. It first came up in the discussion of your paper, Rachel, of the time it would take to get that product ready, as opposed to the product already being ready in those prior cases.
Well, so one of the things that I think makes Gilead a really great company is that they partner with smaller companies all around the world and really help them develop the skills to make these products safely and effectively. So, it might be that manufacturers around the world are not ready to come to the FDA and ask for approval, but it might be that they're a lot closer than we think. So I think from a technological standpoint, we're probably closer to that for Sovaldi and Harvoni than we are for some of the other products, just for that reason.
Yeah. And so, I mean, I think that's a very important feature, and also part of the specificity of this case, right? Mm-hmm. Because we can imagine other drugs that are important with companies that have not done such a thing. But it's that, this is where I'm just trying to think logistically about, taking your question to heart, Josh. About,
I'm not asking for all the reasons this can't be done at the moment.
No, not can't be done. Yeah. But to think that if this is a path to go down, which I agree. I think Aaron's big picture is right. Like, I think we've had 4 hours of discussion of why this is really a remarkable pathway that really merits being pursued seriously. But this is something that comes in my mind, this idea of pathway that it takes to get to work with a prospective manufacturer of this cheaper version to get there, and trying to think about how to hit those points and figure out what that time frame would be, and what complications might ensue there.
I'm hopeful there's also an if you build it, they will come aspect to this. So, the generics industry doesn't totally flourish until after we have an ANDA pathway maybe, and there's a procedure for them to take advantage of this. And so I think at this point, have no trouble believing that could happen. But, of course, to consider.
Oh, and again, for me, this is not having any trouble believing it would happen, but thinking about the differences between, say, the small molecule generic industry and Basaglar.
I don't think you can do this for biologics now.
Yeah.
Yeah, I don't think we're there scientifically.
But so just thinking that out, that if we have the ability to shape this prospectively, how to shape it so that the price points that these drugs come at aren't similar to what's happening with the sort of meager 15% reductions of Basaglar. And Rena, I think this is something that comes into this discussion of royalties, is to what extent the cost includes what cost projection we're expecting to get on paying for the actual cheaper price version, if it doesn't come at as cheap a price as we're hoping for. I may not have phrased that very eloquently, but the question I'm thinking of here is exactly, if you build it, they will come. How to build it most effectively to see that kind of price reduction that we're hoping for.
Right. So I think certainly one key point is, even if we put a path out there, there are a bunch of other things that could come up along the way. That's for sure, including actually finding the manufacturer. But in terms of the major areas of, there are always things that could come up, and we'd have to see. But there's nothing that is really blocking this path that we could see at the moment.
No.
And that it is. I think that, so let me then focus on this question, the interaction of voluntary licensing discussion with 1498. Would it be fair to say that if Dr. Gee wanted to ask Secretary Price about how to move forward, that these two things should go together? Should they be sequential? Should it be only one or the other? Any strong feelings about that?
I mean, they're sort of inseparable in some ways, because as soon as you put forward the idea of the involuntary license of 1498, you may get a voluntary license, like in the Cipro anthrax example. So I think that they have to be realistically talked about together, just because I think realistically at this point, when Gilead has already recouped 3 or 4 times what it costs to buy the initial compound and bring it to market, it could be that in this instance, if it became a real threat that states were going to use 1498, they just want to avoid the possibility entirely and would supply voluntarily. I don't know what others think of that, but
yeah, I mean, I think whenever you negotiate, you do so in the shadow of the law, and so if there's no real threat to invoke 1498, the negotiation is somewhat toothless.
Yeah.
And going to the point about building an initial come, I think when you negotiate, if you have Gilead come to the table as a willing negotiator and the threat of 1498, then you could address a lot of the other practical issues. It would be possible, you have Gilead provide the drug. You don't need to go out to another generic. And practically, Gilead's already underserving this market. So if they only care about making money, then getting some money instead of no money seems like it would be a reasonable thing for them.
And I do have to put this on the table, which is that there are additional legal considerations involved in that circumstance. So Gilead would say that they're concerned about the best price rule. They're granting a lower price for this use would threaten their ability to
Serve the private sector.
But they can get around.
Well, I mean, it's for Medicaid. So the minute they do it for one of these other populations, it triggers in all 50 states the Medicaid population. So that would be of concern to them, unless they were willing to come to the table on a more general basis, and they might, right? They might say, we're going to reach this agreement, and you have to promise not to do it with Merck or AbbVie government, and if you do, we'll supply the entire population.
Also, they can get around the best pricing rule by doing an authorized generic.
Right.
So
yes,
that's right.
So is the question, Josh, sort of, are you trying to kind of craft a very practical, do these 3 things next sort of approach? Or a kind of big picture recommendation of, we think this is something you should pursue, and, here's roughly what's required. Because I could see, we could have a long discussion on those at the end of the day about if you were going to ask Secretary Price for something, what exactly would you ask him for? Would you say, call these companies in and make them negotiate for all 50 states? Would you say, give us the freedom to do this in our state Medicaid and push the FDA to quickly approve any applicants who come forward? I mean, I could think of a lot of different ways, for example, to structure a request. Is that the level of detail you were hoping to get, or?
Well, I think we're going to want to be somewhat detailed. I think I'm most comfortable responding to her interest in Louisiana, because she's sort of framing it that way. She's not saying, help us give advice to HHS about the whole country. I think there's some natural consequences for the rest of the country based on what we would say. But I think our goal is going to be to say, look, if this is a path, you're responsible, you feel responsible for people in your state, this is a path that would be the most viable, we think, to be able to get what you need for people in Louisiana. And so, I think the idea of bringing voluntary licensing together with 1498 makes sense to me. And then we would be able to we probably can't get to, here's a draft of the letter, but I think we should get as far as we can into why we think this is an appropriate approach, that it's a reasonable thing to ask for, and then a little bit of the how in terms of what kinds of things the HHS would need to do to make it work for Louisiana. I do think maybe we put some considerations or something that she may want to recognize that there are obviously implications for other states. I think if we feel comfortable saying that there are certain standards for an area that like it should require someone who wants to solve the problem of hepatitis C in their area, then the natural thing for her to say would be this should be available to anyone who meets those basic standards, you know. But I don't think we need to look at it from everybody's vantage point. I think we're giving her the best foot forward. But if you have, you know, and what we'll probably do is, you know, work on a draft and send it around and see, get everybody's ideas. I think we're going to, for more than just this seems like a potentially viable idea, to hear the things that, you know, either we know or we know would need to get worked out. Do you have specific thoughts in mind, Amy, in terms of what you would imagine a letter from the secretary to the secretary would be?
I think it would be nice.
I think that, you know, one way to do it would be to sort of say clear the way for us to do this, and so give us the kind of way. I mean, so in our paper we get into some detail, but surely one could even, you know, spend more time on this topic of sort of how do you make sure you can cover Medicaid, who are the purchasers, right? So, and I don't know the state-by-state variability of that question. You know, I mean, I'm assuming that what we're talking about is covering, and I'm sorry because I missed some of the middle discussion here, but if we're talking really about reaching Medicaid patients, then what you'd want to do to really make this practicable is to have the, you know, the kind of intermediaries who are purchasing those drugs feel like they were insulated from legal liability for doing that, which we've thought would require some kind of statement from somebody like, you know, the head of HHS to say the federal government considers this for federal use. And that's, yeah. So you could think about asking for that kind of a statement, saying we want to proceed on that basis. I think part of the question is also like, how far do you have to go down the road to make this seem like a real possibility? So if she, for example, herself wanted to say, I want Gilead to come to me, and I want them to come, like I'm going to offer them, and like I want to negotiate with them. You know, like, do you have to work out all of this, or do you just, I mean, so this is, do you just have to work out some of it? Like, I mean, if you really, I'm thinking here about what Massachusetts did with respect to Gilead, right? Where they just threatened an unfair, you know, competition lawsuit, kind of in order to get Gilead to come to the table. But they didn't go that far down the road of explaining exactly how they were going to do everything, right? And I don't know how, I don't know exactly if what we're thinking is she should ask to do this because maybe Tom Price will agree and ultimately it could all work, or she should raise this as a real possibility, in part with having in mind the sort of idea that they will then negotiate themselves.
I see. Yeah, I think the answer to that question is we should be writing something we think could work. But we will recognize, because of this discussion, that it may trigger a different kind of conversation that she's then able to have for the state. But I think we should go as far as we can to setting out what the path would be for 1498, because it may in the end be required. But you know, we'll see. I think where we know that there are details that would be helpful, like a statement from the HHS secretary, I would say we should put that in there. Where we don't know, and there may be certain issues that FDA is going to be best placed to work out by itself, we should say then you need a plan with FDA that would accomplish the following goals. But we may, you know, and there may be more than one way for FDA to do it, they'll figure it out. So I think we should try to suggest to her the best path that we can think of, and we've had plenty of discussion on so many different topics today. We will go back and do our best based on the discussion to do that and get all of your input.
I have something to add related to this, which is again about pricing. So one argument we could have, one conversation that could be had is, well, let's just wait until the generics come into the market, and then we can treat a lot of more people than we do currently under the current branded price. And my kind of argument against that would be, no, this is urgent. This is urgent from a public policy perspective or public health perspective. in that the longer we wait to treat this infection, the more infected people we have. But also, even if under best circumstances we had a generic that entered in 2018 or 2020, we're still looking at prices that would be on the order of $10,000 to $11,000 per person. And if we just kind of projected out what we see as being kind of 90% off list after 2 years of generic entry and more than 2 competitors entering into the market. So that's still large, and still a large per person payment, and one that is on the higher end of my calculation for under royalty method 1 or royalty method 2. So we're still looking at, with generic entry, we're still going to be facing a situation that is potentially budget busting.
Thank you. All right. Any final comments as we're wrapping up? I want to thank everybody here for participating for this 1498 session, and I again thank Madeline and Joy and our whole technical team and all of you from wherever you are around the world, Rena, Aaron, and Amy for joining us, and we will be back in touch. Have a great afternoon.